Item 1 WPC 1161.
In the instant case, the written statement is absolutely vague and apparently has not met the requirement as laid down by the Honorable Supreme Court. In the case of Sarvananda Sonwal, there is a requirement to disclose the following: his date of birth, place of birth, name of the parents, their place of birth and citizenship. Further, there may be a requirement to give the details of the grandparents. It has been stated that all these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. In view of the above, we do not find any fault with the opinion. The writ petition is dismissed. Interim order is vacated. We have not found any fault with the opinion. Petition is dismissed.
My lord, I get to mention item number 44, orders matter, my lord. This matter may taken up at 2 p.m. There is an IA, my lord. IA in disposal case, my lord.
IA for?
IA for, my lord, extension of time and, my lord.
We cannot say
A
at 2. If
direction,
it reaches
my
in the
lord,
first half, then we can defer it to 2.
My lord, earlier the expert order has been set aside by the coordinate bench, directing that
Mr. Ahmed, if it reaches in the first half, we can accommodate you in the second half. If it doesn't reaches by 2 o'clock, we cannot give preference to your matter.
In the second half.
If it reaches in the first half, we'll adjourn it to 2 o'clock.
Second half, yes.
Obliged.
But it has to reach first.
May I please your lordship, my lord? My lord, I have here in item number 4, my lord.
Hmm.
My lord, I have the instruction to withdraw this petition, my lord, with liberty, my lord. They will be filing one review petition before the concerned tribunal. I know, my lord, this is an old matter, my lord. But the instruction is that, my lord, they will file a review petition. My lord.
Review petition.
Yes, before the concerned tribunal, my lord. Therefore, my lord, I'm withdrawing this petition with liberty, my lord.
Okay.
Praying before your lordship.
But review is there is a time, of course,
I understand,
it has to
but-
be in accordance with law.
I have been instructed, my lord. to
Okay.
be-
Yes, madam.
Third, I had to again fix for hearing today, and we had to submit on the oral evidence.
If he wants to withdraw, let it be withdrawn.
Yes,
Well, let us have the file. Item number 4. Heard Sri so-and-so, huh? For the petition also heard Sri so-and-so. Para? Sri Ahmad, the learned counsel for the petitioner, has submitted that he has instructions to withdraw this writ petition, which are liberty to approach the tribunal by filing a review. Full stop. Para? In view of the above, writ petition is dismissed on withdrawal with liberty. Full stop. It is, however, made clear that if any review application is filed, the same is required to be considered strictly in accordance with law.
my lord. One line may kindly be added, my lord, if necessary, my lord. The LCR may kindly be sent back. My lord.
LCR is here. There.
Yes, my lord.
TCR. Consequently, we
TCR.
direct the registry to forthwith send back the TCR, their records to the concerned so-and-so tribunal.
Tribunal court records.
The instant application, instant application has been filed challenging so-and-so, so-and-so, huh? Yes.
Deeply.
Maybe.
Good. ইয়াতে ওলাই দিব।
May I please, Lordship? I beg to mention item number 19, Lordship, 19.
Yes.
Lordship, today I have some personal difficulties, Lordship. So any other day may taken up.
19 is a 19 matter.
Yes, Lordship.
What personal difficulty do you have?
I have to leave, Lordship. I have to go Nalbari, Lordship. Today I have to go Nalbari, Lordship.
You have to go to Nalbari.
Yes.
So 19 matter has to be passed over.
Yes, Lordship.
Okay, when? Today, is Friday. Day after tomorrow.
Next Monday, Lordship.
Okay, Monday next. What is your name?
A.S. Ali.
On the prayer of 3 A.S. Ali, learned counsel for the petitioner, has prayed for an adjournment. First of, however, considering that this matter is pending since the year 2019, we have reluctantly acceded to the said request directing listing of this matter on Monday. Acceded the ACC, huh?
Obliged.
18 hoboni.
Last chapter 46. Can it be taken up at 2 Lordship? 46.
Admission matter. If it reaches in the first half, we'll defer it to the second half.
Wait, just wait, sorry, my lord. I beg to mention item number 17, my lord. That may be taken on next week on energy, my lord.
Why are you seeking time?
Today, my lord, I have some difficulties, my lord.
No, you cannot adjourn matters of 19 like
Next
this.
week, my lord, only any day, my lord.
We'll have it on Friday, not
Right,
next week.
next week, my lord, on Tuesday or
Oh, we are seeing that 19 matters are
on
often
Tuesday
either
or
time being
Wednesday,
or
my lord.
next week.
on
Why?
Tuesday or Wednesday, my lord.
Monday,
Tuesday, my lord.
Monday. Next, same order, 17. As Islam, huh? Same order into 18, 19 or Islam, 18.5.
Oh, nice.
May I please the Lordships? I'd like to mention for listing a writ petition regarding FT cases on Thursday. Tomorrow.
Fresh matter.
Yeah, fresh.
When did you file?
Day before yesterday.
Okay, you can have it on Monday also, whenever you want.
Friday it may be.
Day after tomorrow.
Day before yesterday.
No, when do you want listing?
Day after tomorrow.
Okay, it can come.
May it please your lordship, I beg to mention item 34 of the daily list.
34.
Yes, yes, lordship.
Yes, what is your prayer?
My senior is out of station today. Kindly the other matter will be adjourned for today.
Who is your senior?
Minto Saikia.
On a request made on behalf of the petitioner, matter is adjourned to be listed on Monday next.
No, after 2 weeks.
Then don't write like this. Don't write like this. A prayer for adjournment has been made on behalf of Sri M. Saikia, learned counsel for the petitioners. Para, on request, matter is adjourned to be listed on 2 weeks. Will be on 29th of May. 29/5. Okay.
I have to mention for adjournment of item number
3. Matter of which year? 19 matter. Why are you seeking time?
item number 3.
3. This is a matter of 2019. Why are you seeking time? Who is out of station? When? Day after tomorrow then. Mr. Chaudhary, you are there?
This concerned file is with my colleague
Is
junior.
there out of station?
T.H. Chaudhary. T.H. Chaudhary.
T.H. Chaudhary.
Yes, ma'am.
Who will do the
Only
case?
small
T.H.
advert-
Chaudhary or you will do the case?
My lord, he concerned file is with him. My lord. That is the difficulty. Otherwise,
Day after tomorrow.
yes, ma'am.
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on Friday next. Friday. Motion 2019 matter doesn't look good. Friday, date to the debate. 15.
Obliged.
Yes.
Lordship, I beg to mention item number 11.
11. Yes. What is your prayer?
My Lordship, advocate, senior advocate, his father expired the day before yesterday.
Whose father passed away?
H boy, I'm the H boy.
Okay. Okay. When do you want? After 2 weeks?
20 or 21.
Okay. A request has been made on behalf of 3H Bhuya, learned counsel for the petitioner, on the ground that he has suffered a bereavement. Para? A request for adjournment. A request for adjournment of this. In view of the above, matter is adjourned to be listed on when? 22nd? Or when? 25th? When, madam?
22nd.
22nd. 22/5 কি লিখিলে এইটো or request for adjournment has been full stop full stop on request list this matter and request list this matter on 22/5
May please, Lordship. Lordship, I beg to mention item number 30, Lordship. In this matter, Mr. Jetterson will appear and he is in Delhi
30
for
30
30, Lordship. For his elder son's admission purpose, Lordship. He is in out of station at Delhi, Lordship.
who's out of station
Jetterson, Mr.
Okay.
Jetterson. Next week,
yes
any day.
next week
Any
on
day.
a request made on behalf of Sri Jed Hussain, learned counsel for the petitioner, matter is adjourned to be listed on 11 and 22nd 22/5
Bless.
I didn't want.
ঠিক আছে অলপ দেৰি বন্ধ কৰি
নালাগে, use it. I'll get used. No problem.
বন্ধ কৰি দিয়েছে এইটো 10 মিনিট পিছত দিব
May it please, your lordship.
your GM Suleiman
Lordship.
Okay. Records have come.
Yes, lordship, they are available. Lordship. Opinion in page 52, lordship.
Just a minute. Any CCC? Who's CCC? CCC? Meet Bisham. Dabir Rahman.
David Rahman.
Alias
21 is
Dabiur.
Elias Dabibur Rahman.
Dabiur.
Dabibur.
No, you written Dabiur outside in the cause in the file. Dabibur.
Dabibur.
Okay. When were the date of birth?
Year of age around 1957.
Year of birth.
Year of birth around.
— 1957.
57.
A written statement filed on which date? WS filed on which date?
Yes.
Date of filing written statement.
Eight 3/18.
8/3/18.
18.
Okay, please lead us to the documents.
Opinion in page 52, lordship.
— 21/7.
Lordship.
21/7/18.
18.
Mr. Suleiman, 21/7/18.
Opinion.
Yes.
Yes, lordship.
Yes. Yes, what are the documents?
Lordship. Exhibit 5,
Page
page 18, lordship.
18.
18 on the right. 18.
Honest is English, 19 is vernacular.
What is this 19?
19.
Voter list.
19 parents, his parents' name.
Voter list.
Voter list. Voter list, 1960.
Certified copy.
Certified copy of it.
Exhibit.
Exhibited document.
Of
19,
voter list of which year?
1966.
1966.
66.
Whose name?
With father and mother.
Name?
Parents. Father's name is
Justice Sheikh.
Justice Sheikh. Justice Sheikh. Mother
Justice Sheikh.
Mojan Nessa. Actually, Mojan Nessa is wrongly recorded. Actually, his mother's name is
Justice Sheikh is how many years?
Motujan Nessa. Motujan.
Justice is your father?
Just father.
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 45. And mother is? Mouzan.
Motujan.
Mouzan.
There is Mojan. Actually, Motujan.
Is it Mouzan? Mouzan what? Nessa.
Mojan Nessa is in the voter list. But originally her name is not Mojan Nessa. Motujan.
Yes.
Then
What is the name of the village?
village Belangamari.
Vengamari.
Village.
Exhibit what?
Exhibit 5.
Page.
Page 18.
Thank you. Yes, 1966.
Thereafter?
Thereafter, page 20, voter list of 1971.
Jasimuddin.
Jasimuddin and mother. Jasimuddin and Motujan.
Justice Sheikh becomes Jasimuddin.
Jasimuddin is same Darshan.
Names are different.
Matuzan.
Motujan.
Mother becomes from 30, it becomes 42. Who is Tabibar?
Tabibur, actually, his name is Dabibur Rahman, actually Tayyibur Rahman, his brother. Dabibur, yes. Dabit.
But what is the name of the village?
Dabibur Rahman is his brother.
What is the village?
Village is there.
This is exhibit what?
Nanglichar.
Exhibit?
Exhibit 6.
Village is number 3, Nanglichar.
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 Language.
Tabibur is your?
Tabibur is brother.
Okay. Thereafter?
Thereafter, page 26. Page 26, voter list 1997.
What about page 23?
20,
89 voter list,
the 20, 89, I think it is not exhibited, Lord.
not exhibited.
Okay. Exhibited.
Thereafter,
Page 26,
even 93 is not exhibited.
exhibited, not exhibited.
Twenty-six.
Uh,
26.
26 and exhibited, exhibit 3. Petitioner and
Voter list of 97.
97, petitioner along with his wife.
Exhibit,
Exhibit 3.
village,
Village Putimari Chapari.
Dabir Rahman.
That is the petitioner.
Amana.
Amana is the wife.
Yes.
Then the
So first time your name came in the voters list of 97,
actually 1989 first time came in the voter list, but
but not exhibited.
not exhibited.
89. 89 was page 22.
Page 22.
'89. Also, if you take into consideration 89, you were 40 years. 40 years of age. Page 23.
40 years.
So there has to be previous voters list.
There is no previous voter list.
93, you are Dabibar. 40 years. Again, 93, same. Yes, thereafter.
There page 32, exhibit 1.
What is this?
What is this?
32 is voter list of 2018.
2018. A printed copy.
Yes.
Last one is 39, that is Gauhati certificate. It's exhibited at exhibit 7.
This 2018 voter list exhibited.
Exhibited.
As? Exhibit what?
Exhibit 2018, exhibit 1. Gauhati certificate also exhibited.
This is not a certified copy.
Yes.
Cannot be a certified copy.
Gaupura certificate.
No, page 32.
That copy.
This certificate not certified copy.
Not
It's a printed
certified.
copy. Printed copy.
Not certified copy.
Not certified. Printed copy.
Even then page?
Page 32.
No, Gaupura
Gaupura certificate page 39.
Please read.
Gaupura certificate.
Yes.
This is to certify that
No, read the vernacular.
vernacular.
39.
39 প্রমাণপত্র দেয়া যে দাবির রহমান পিতা জসিম শেখ গাঁও বেলেঙ্গামারি ডাকঘর কসুমারা মৌজা সোয়ান্স এলিজিবলশিপ আৰু 1966 চনৰ ভোটাৰ তালিকা নম্বৰ 82 কমিক্স নম্বৰ সিরিয়াল নম্বৰ হাউস নম্বৰ 18 খণ্ড নম্বৰ 106 সমষ্টিৰ 54 চেঙ্গা বিধানসভাত নাম তালিকাভুক্ত তেওঁ বেলেঙ্গামারি গজাখনিয়াহৰ ফলত উঠি গৈ দৰং জিলাৰ মংগলদৈ সমষ্টিৰ অন্তৰ্গত গাছবাৰী গাঁৱত বসবাস কৰি আছে।
He's a Gaupura, which place?
Page 39.
Gaupura, which village?
Gaupura of village Kochumara.
Which village? Which district?
District Dorong district.
Translated copy says Borpeta.
Borpeta.
Translated copy at page 38.
বেলেঙ্গামারি গাঁৱত দৰং জিলাৰ সমষ্টিৰ অন্তৰ্গত wrongly translation lordship it's Dorong. Wrong translation. Borpeta. I think copy paste. I think
This cannot be copy paste.
oh yes.
Apne original to some.
Or we have to see.
Oh.
Borpeta nahi?
No,
Borpeta. Dagor Borpeta.
When did you shift to Dorong? The Gaupura had adduced evidence.
No, lordship.
How many witnesses?
Only one witness. Only petitioner. Only petitioner examined.
You don't have any case, Mr. Suleiman. We thought, see, apart from the discrepancy, there is no proof. There is no voter list to connect you with your parents. And you, the most important factor is that your date of birth is 1957, as disclosed by you. So we like to see a voter list of a period when you first attained the age of franchise 21 years. If you are 57 born, then 67, 77, 78 onward, 78, 79.
79, 78.
78. You have given 89 voter list not exhibited. There your age is 40. 93 voter list not exhibited, face 40. 97 exhibited, face 45. And there are discrepancies in the name of your father. your own name. Your father was initially Jassi Sheikh. It became Jasimuddin. Then in voter list of 97, you are son of Jasim. Then in 2018, you are son of Jasim Sheikh. It's an uncertified copy. Gaumbura has not produced evidence. And he belongs to the Senga village. How does he know where you are now staying? But that is besides the point, because he has never come to the witness box to produce evidence. I don't think you'll have a case. Anything else?
Lord, I leave to you. Lord.
Yes, madam.
Lordship has seen
The documents are totally lacking.
there's no link at all, Lordship. And discrepancies and father's name, as Lordship has just pointed out. Then Lordship 66 and 71 voters list, mother and father. There is, both the villages are different. 66 villages also different and 71 villages also different, which at page 18 and 20, Lordship. 18 is the 66 voters list.
Yes, 66 we have seen village Bhelengamari,
Mari and
and 71 is number 3, Nanglichar.
after that, Puthimari has been consistent till 2018. After the petitioner's name appears in 1989 Lordship, it was not exhibited. Then Puthimari is consistent in all of them, but not exhibited. Then the 2009 and 15 are exhibited, extra copies not exhibited. Gaumbura's certificate will not hold much, not give him much help, Lordship, because it is not as per the procedure, and Gaumbura is not authorized to issue certificates of this kind, Lordship. His only linkage comes from the Gaumbura certificate, which is also not clear, Lordship. Gaumbura is of which village, that is not clear. Then it states Jila Borpeta. And he has known him, but how old?
Where do you get Jila Borpeta?
On Lordship, in the translation copy is also there, and in the vernacular page 39. My friend just read it out to me on 1, 2, 3, 4, fourth line, the last. It is
Yes, Romandia, so and so, so and so, Moses, so and so.
completely lacks none of the documents with the his projected father, Lordship, projected parents.
But this certificate is also very, very confusing. He says that you are a voter of Senga Vidhanabha. You are a voter of Senga Vidhanabha, and yet, and you are a resident of Velengamari. Velengamari is in Senga, Borpeta. But last line, তেওঁ গৰাখহনীয়াৰ ফলত উঠি গৈ দৰং জিলাৰ মঙলদৈ সমষ্টিৰ গেপ অন্তৰ্গত গাছবাৰী গাঁৱত বসবাস কৰি আছে। Where have you pleaded about your shifting in the written statement?
Not elaborate.
Written statement not annexed.
Next.
But page,
It's not mentioning.
In page 46. English.
And only in the year 2018, he was marked as D also.
46 seconds. Statement 46. Written statement is also vague. Page 46, 47.
Statement is at 54, Lordship.
Written statement is at page 46. 46.
For me, 46 is something else, announced documents. And it
Now there has
should
been correction of page. You see 52 perhaps in your
54.
54 or 54. 54 has been corrected.
66 and 71, father and mother's name also changed, Lordship, in both the voters list. So his linkage to his projected parents is not being performed. And his voters list ought to have been there prior to around 1977. Lordship, for the Gauhati certificate, I would like to rely on Mahiruddin, Lordship. WPC 576 of 2019. Mahiruddin versus Union of India.
Ma'am, can you repeat? 57?
What is it? What is the proposition? Why?
Gauhati is not authorized to issue a certificate under the executive instructions, Lordship, part 3, chapter 1 of the Assam Land and Revenue Regulation 1886.
Please give the
Certificate regarding this.
This certificate which he is relying on for his linkage, Lordship.
Regarding residence.
Please give the citation or the case details. 2000 what?
WPC 576 of 2019.
WBC 5719.
6 of this, Lordship.
Name?
Mahiruddin, Mahiruddin.
It must be a reported case probably.
This
We'll check up.
I have the,
Don't have, no?
but I have the WPC number.
What is the date of disposal?
6/5/2019. Paragraph is,
Please read.
the DW2, the Gauhati.
Paragraph 4.
No, it is not about.
Okay, doesn't matter. Read the relevant relevant.
In Paradise Lordship, the DW2, the Gambura in his deposition has stated that he knows the OP for about 22 years. And at present, he resided at village Bagmarachar and his father's name is Kanu Sheikh. DW2 has stated only that much. He also stated he had issued exhibit EN1 because he appeared not to. These two lines of statement fail to furtherance the OP's claim. Firstly, the Gambura, in the capacity of the village headman, had issued the said certificate, but he had no assessment of OP's family, nor he had disclosed any material facts such as the date of birth of the OP, name of OP's mother, as well as about her grandparents. The fact that OP is residing to the same village with the Gambura is not sufficient to issue a certificate under Executive Instruction Part 8, Chapter 1 of the Assam Land and Regulation Act, Assam Land and Revenue Regulation. The said executive instruction of the Gambura does not authorize a Gambura to issue such certificate, and as such, it has no legal sanctity and cannot be treated as a legal certificate. And hence, Exhibit E renders it admissible in evidence. Secondly, besides the Gambura certificate may not be admissible due to use of the state emblem on the top of it without any authority. Such improper use of the state emblem of India by itself renders inadmissibility in evidence.
As per this law, the Gambura cannot issue a certificate that so and so is a resident of this village of which he is Gambura.
Even if
He cannot.
No, Lordship, he cannot. And then he is using the state emblem.
No, that's different. That he cannot.
He cannot.
But that so and so is a resident of my village where I am Gambura. That cannot be done. As per this judgment. Some land revenue regulation.
The only document which could have helped him was the Gambura certificate, Lordship, and that too doesn't help him now after this addition.
Okay.
Lordship, for WS, we can again rely on Rashmi Nara like yesterday we had. It Lordship allowed and just leave it out. 2017 4 GLT 346.
17.4 GLT.
Yes, Lordship. 346. RASHMINARA, Rashminara Begum.
Madam, the paragraph,
Lordship, page 25 and
page no, 20, no, paragraph.
25, Lordship.
Page 25, how can it be?
25. Para 25, Lordship.
Okay. Look for it. Huh? Okay, we close this. James Suleiman, and write the other names. Hearing is concluded, judgment will be revoked. But we may indicate that is likely to be dismissed. There are no materials, but we'll still consider.
Para 25, Lordship. Written on the last one.
Which judgment?
Rashminara.
All right.
Item 2.
May I please, Your Lordship? Input order is at page 15 and Lordship. Petition has been declared as foreigners.
You'd like to apply under CA? Huh? Would you like to apply under CA?
Yes, Lordship.
You can close this. Give liberty. Heard Miss J. Paul, learned counsel for the petitioner. Also heard Miss Swenson. The instant B. Sharma Orikiba, CDC B. Sharma. The instant application under Article 226 of the Constitution of India has been filed challenging an order it is so passed by so whereby the petitioner has been declared a foreigner post 25/3/1971. Full stop para. Though various grounds of challenge have been made, Ms. Pal, the learned counsel for the petitioner, has submitted that instead of pressing the present application, she may be given liberty to approach the appropriate authority under the CAA, Citizenship Amendment Act. Huh? Full stop para. Yes, madam.
Yes, Lordship.
The aforesaid proposition is not objected to by the learned counsel for the respondents. Para. In view of the above, the writ petition is closed with a liberty to the petitioner to approach the appropriate authority under the CAA, and if such approach is done in the manner prescribed, the same is to be considered in accordance with law.
Complied.
Item 5. Yes, Mr. Chalia.
My lord, petitioner hearing challenging an ex parte order passed by the Gauhati.
This matter may be taken in the presence of Mr. Pangi or something.
No, I saw the court call for the original reports from the tribunal. There, your lordship will find it is a question of whether service was properly served or not, since it is an ex parte order. There I found in the notice, their name was not proper.
Is it in this way?
Original record is one.
Yes.
Original record.
What is your name, Mr. Chalia? Faznur. Faznul.
Haznur,
Faznul.
Hazlul Haq,
Faznul of Fazrul.
Fazrul Haq.
Hazrul Haq,
Fazrul.
Hazrul. And the notice in the orders of the lower court file, tribunal file, I find 20th.
Can you have a look,
In-
madam, of the
In the,
aspect of
in the reference order, it is Hazrul Haq.
now, what is the report of the Jari Karok?
Notices were served in the address where the petitioner once lived for about some period in 11 or 14. And that was the address given by the police in the investigation report. And the original, his permanent address was also put there.
Permanent address was?
Of the petitioner
Oh,
was also there.
okay.
But the tribunal accepted the notice served upon the A by alternative means because by
Substituted manner.
substituted manner and was never sent to the permanent address.
It was affixed to the house or what?
That
How was it
not
done?
very clear.
Jari Karok report?
That I thought.
Mr. Sharma, please help senior counsel with the records. There's the report of the Jari Karok.
Just remind that of us, no?
Around. No, number
বিচাৰি গৈ স্থানীয় লোকক গাঁৱৰ গাঁওবুঢ়া সোধ-পোছ কৰাত মহম্মদ ফজিলুল হক নামৰ কোনো লোক
নাই বুলি কোৱাত সমনৰ অচল কপি সাক্ষী লৈ
গাঁওবুঢ়াৰ উপস্থিত সাক্ষী ক্ষেত্ৰত সমনৰ নকল কপিটো সকলো লোকে চকুৰে দেখা স্থানত লটকাই জাৰি
কৰিলে।
Where? 7279.
কিন্তু দেখাত পালাম
Huh?
Some in a proper place where it can be seen by all.
Conspicuous place. Conspicuous place. Date of the report. Date of the report.
Date of the report, Lordship. It is 11/6/2018.
Okay. Today's. Here. 29, 5, 26. Okay, we'll allow this. But you have to appear on 20.
Yes.
Are you on bail? Are you on?
Yes, Lord. But one thing
No, are you in custody?
yes, no, I've been granted bail, earlier order.
Okay.
I appeared there and I've been granted bail by the Boda police. But thing is, I am permanently settled at Golpara. Huh? Dhubri. So my prayer will be that if it is allowed, then I have to be instead of in Saraido or Sibsagar.
No, that power we do not have. We have
To
already-
transfer.
full bench. We have ruled. Unless this tribunal is not functional, exceptional circumstances we can transfer. You have to contest. 29/5 we are giving the date. You have to file written statement along with the evidence. And from that day, the tribunal will take charge and try to complete the matter in accordance with 314.
And no further notice.
No further notice.
No,
Same
no,
notice.
here, no further notice.
Same notice. আমরা এখানে বিলো এলো ডেট টু 29/5 নেক্সট ডেট হ্যাঁ এই কিবে মারিছে কি
আছে না মন্টিয়া
কেভি
হবো 29
জারি করা রিপোর্ট টু 11/6/2018. Yes, but your date of appearance is
29
29/5.
Mine.
We'll have the order today itself.
My lord, my lord.
Our bail already আছে এখানে প্রথম order ওটাকে bail দিব না লাগে bail will continue till the 29/5. Before দুইটা order লইলো আর তুমি মারি দিব ডিফারেন্ট একদম ইজি হয়ে যাবে রিসপন্স দাও and সবাই তো লিখিব প্রথম দিন লিখিব Art 3D picture yeah Leonard Cine counsel assisted by M. You know M. Roy, the petitioner, also Art so-and-so. This is an application of so-and-so challenging so-and-so. And this is going to compile the paper as an against. Dispose it. Yes, next.
Item 6.
New matter,
Yes, lordship.
fresh,
Yes, lordship.
opinion dated,
Opinion dated lordship 31/5/2025 lordship. We had filed it, but the coordinate bench cannot take it up, so it was pending.
when did you file it?
I filed,
11/12/2025.
yes,
Okay. Heard, Ms. G. Ghosh. But have you instructed your clerk to write
yes, lordship.
in a legible, readable
Yes,
handwriting?
lord, yes, lordship.
Even your name is not readable.
I told him, and even the video
It
clip
looks
I had,
like Mrs. G. Goswami.
I told him, lordship. And I told him that even the video clip, I had showed it to him, that this is the situation. He said that from the
You
next
see, if
filing.
you can read the constantly. The. Thank you. See the names? Can you read, Madam Verma?
I can understand. I know his handwriting is very bad. Lord.
Then let Mr. Sharma read or Miss Kotoki read.
I know that he's,
You'll get a prize. You'll get a prize if you can read it.
and he is for a long time, lordship. Before I joined the profession, he was with many senior advocates also. He assisted.
He should have been a doctor actually.
He has assisted even. He was with many.
Nowadays, we are encouraged to have type prescriptions. Medical.
Like, they write caps. Now medicine they write in caps, lordship.
There is a medical transcription. So whatever the doctor says, it gets typed to avoid any confusion.
I told him on the last occasion only, I told him this is the situation. But to change him also, then also. It's
Don't
difficult.
change him, you write yourself or write through an associate. Isn't
NHM and all, we do it. Page number also we do it because his handwriting is so bad.
heard Ms. G. Ghosh, learned counsel for the petitioner who has put to challenge judgment in order to so-and-so, whereby so-and-so, put taken 71, post 71.
Yes, lordship.
Post 71. What are your main grounds of challenge?
Discrepancy with regard to the age and but
Your challenge.
uh,
What are your grounds of challenge?
we have stated, lordship, that all the documents which he has relied upon has linked up to her parents, lordship.
It is contended that though there were relevant documents to establish the link,
Yes,
those were not properly appreciated by the learned tribunal. Sarah, let notice be issued, returnable on 22nd of June 2026. Union of India, B. Sharma, CDC 1. Home Department, Madam Verma for 2 and 2, 4, 6. 4 and 6.
Be Mr. Sharma, lordship.
2 and 6.
For 2 and 6, 2, 6 and 7.
7 is not 7. 7 is the officer in charge. 7 state will take. He'll take, okay. 2, 4 and 7.
2, 6 and 7.
2, 6 and 7. Who is 3? Election Commission of India. Mrs. Kotoki 3. Then 4 G Sharma Standing Council NRC. Then District Commissioner P Sharma, State Council 5. Extra copies. Call for the records. Registered to give the requisitions and to us. That's all of it. Madam prays for an interim order. Submitting his outside custody. That's why to 5,000. Yes. You'll appear when? On or before? We give a date. Today is 13th. On or before 22nd of May. You'll get a certified copy today itself.
Yes,
20 on or before 22nd of May.
deeply.
I did 7.
May I please the Lordship? Lordship is a contested matter, my lord. Impin order as with 79 minutes. This matter, my lord.
When did you file it, Mr. Mubarak?
January
January
22.
26, when,
Lordship.
and the opinion dated?
Lordship 13/6/2019, my lord.
19.
That is why, my lord, we have filed our additional affidavit, my lord, explain the delay, my lord, on the last occasion, my lord.
Okay, we'll issue notice, sir.
Lordship.
Third, 3A Mubarak,
Lordship.
learned counsel for the petitioner who has put to challenge, who has filed his application under Article 2 decision of council, putting to challenge so and so, huh? What are your main grounds?
Main ground, my lord, the documents has been produced by the
Proceeding.
petitioner, my lord, proceeding. But that has not been discussed, and the evidence, my lord, it is the evidence, and evidence also not discussed in this matter.
It is contended that the impugned opinion has been rendered without proper discussion of the documents
As well as the evidence.
established and the evidence
Lordship.
adduced. Para. Ms. Verma, the learned standing counsel, has however raised the objection of delay and laches as the opinion is of the year 2019, and the same has been put to challenge in after a long gap of about 7 years. Para. Be that as it may, that notice be issued. Returnable on same date. Control Kuchile Matra, Vice Kuchile 22nd June. Yes, we will. Union Vidya, B. Sharma, 1. Non-home and political madam, 2, 2 and 4. District Commissioner 3 by P. Sharma. And State Coordinator 5 G. Sharma. Election Commission India 6 S. Kotoki. Extra copies. Upset. Call for the records. Requisition, huh? The aspect of maintainability of this writ petition on the ground of delay and laches is however kept open. Yes.
But
Lordship, petitioner is already declared as not a foreigner, Lordship, which is, the order is at page 29.
What is your grievance?
Not 29. Grievance is that, Lordship, I'm already being declared as not a foreigner by the Foreigners Tribunal, Kamrup Metro, in an FT case, Lordship. Thereafter, I received a notice from Foreigners Tribunal, Gwalpara, Lordship. I appeared, I submitted the order, and I have with the petition to be the petition to be dropped since it's barred by res judicata. So thereafter, the order that petition was not allowed. But first of all, was documents has to be submitted. So all the documents, whatever he has exhibited before the Larne Tribunal, Kamrup Metro 1, he has submitted all the original documents there. Thereafter, also direction was made to file the written statement. This is the case of the petitioner, Lordship.
Not applicable. Res judicata is not applicable.
Applicable, Lordship, Abdul Quddus, judgment, Lordship.
More materials immersed then, different materials immersed then.
Yes.
I think it's not applicable, perhaps anyway, so we'd have to see that.
Page 41 is the order wherein he was, in that opinion, he was declared as not a foreigner.
Where is the impugned opinion? Page?
Order sheet, which I have an. Next is a page 32, Lordship, order sheet. I have annexed the entire order sheet. Page 37 is the copy, Lordship. Learned Counsel submitted Hajira and certified copy of the voters list.
But why do you make the index? Why do you make an index? It is for beneficial of not only the court of all. Have you seen the index? You have not even stated which order you are challenging at page, index page. The opinion date is not there. Page is not there. You have rather given the opinion of Kamrup.
Yes, wherein I am declared as not
No,
a
that is
foreigner.
okay. But index, aren't you required to give? What is the purpose of an index?
I have actually annexed one and the order sheet, entire order sheets.
Which page the impugned opinion is there?
The OP with a written Hajira case list, initial stage, hence the directed to
Which
submit.
page?
Page number, Lordship, page 39.
Impugned opinion.
44 is the Kamrup opinion. 44.
No, 39, Lordship.
No, it starts like that.
Yes, Lord.
Starts with 41. The Kamrup opinion is 44, if I'm not mistaken. Abdul Latif is not a foreigner.
Yes.
Yes, madam, we should notice this case. What do you say on the Abdul Quddus?
Lordship, there have been decisions like they have to go and prove themselves there also that they're one and the same person. If there's another difference pending against them. And she has already started, she has appeared, she has given her documents. So it would be better if Lordship can close this matter and ask her to go and prove herself there also with the same documents and the same judgment.
Only that aspect has to
Only
be
that
the
is-
same person.
Yes,
Sa-
one and the
same-
same person. That's it.
The finding will sustain,
Yes,
not a foreigner.
yes. It is for that
I
tribunal
had
to
given-
look into the same documents, appreciate it and then pass the opinion, Lordship.
No, that would be an academic exercise, but the first part, whether it is the same person, that burden one has to discharge.
Yes, Lordship.
Yeah, have you given the?
Original documents I have submitted, whatever I have exhibited before the learned
See, we
tribunal.
do not
come-
want another adjudication process.
Yes, Lord.
Cannot be.
Yes,
Once it is
Lordship.
adjudicated, but
Yes.
there may be new materials, number one. Number two, there may be an a question of impersonation. So only to avoid that, you need to go and say that I am the person, I have already faced the proceedings and the opinion is in my favor.
Yes, that he has stated. In that petition only, he has stated and he has annexed all the documents. And then the direction of the tribunal was to submit all the documents which was there. So he had submitted all the original documents.
Thereafter, what happened?
Thereafter, again, direction was given to file the written statement.
The process has to be completed, Lordship.
So WS and evidence, if I have to go through the entire process again, then if I go to next district,
Now, there is no opinion as such. Is there any?
no opinion as such, Lord.
You are impugning the process,
Yes, Lordship.
second process.
Yes, Lordship.
Okay.
Already, but with due process that to show that I'm the same person, I have filed a petition along with the documents whichever I have exhibited.
What is the procedure? We'd like to be
Lordship,
enlightened.
Examine, call for the records. You can always, Lordship can examine whether the notice served now and earlier are.
No, not on that. What is the requirement? Is there a requirement to submit another written statement?
No.
Usually the.
No.
Different benches have taken different stands, Lordship. Many.
And kindly enlighten us what is the law on this field?
Lordship, if Lordship fixes it on 18th, I will appraise the Honorable Court on that issue, Lordship.
with our judgments.
But
that-
a reference can be initiated.
Ref-
No part. I mean.
Yes, Lordship, and that is the, yes, Lordship, but that is a devoter case, which, because he hails from the district of Gwalpara. So that is a devoter case. And he came to Kamrup Metro for a work, so that is an FT case. So wherein he
Two
received,
references has been initiated against him.
yes,
So he has to answer both the references.
this is the reason. All then it will be, if I go to third district for my work purpose, then I'll have another reference against me. Then again I have to, if I go to fourth district, so it will be an endless number of exercise, Lordship. So he had done,
No,
he
it's
appeared.
not- You cannot take a hypothetical example that an endless, nobody is facing an endless number.
He,
But we would like to be apprised, what
Yes,
is the
Lordship.
law? How do you proceed?
yes, Lordship.
Will you-
I'll satisfy
Is it
Lordship on that.
required to explain to tribunal by way of a written statement? Or,
Lordship, I can understand from her submission is, she has been marked D now.
Not now.
Because- No, because
19,
the second reference, she said, in Gwalpara reference, he was marked D. This Gauhati reference is of 23, is the order where she was declared an Indian. So if Lordship calls for the records, I think picture would be.
Both the records there, Lordship.
Yes, yes.
Both the records.
no, that option is always available to us to have the records.
He was marked D prior to passing of this judgment or after passing of this judgment, that has to be determined and seen, Lordship.
Okay,
Because
let's-
if he was marked D, it would have been long time back and maybe the case came up now.
Or one aspect of the law can also be this, that suppose in this kind of a situation, as Madam has said, instead of the entire exercise being repeated, which obviously will cause some,
Time and
to him.
prejudice, yes.
So learned tribunal can record a finding regarding the identity on the basis of up to written statement,
Okay.
something like that.
Another thing,
On the basis
Lordship,
of document.
that what tribunal will also have to examine is whether he was marked D prior to passing of this. How come a person marked D in Gwalpara is declared an Indian citizen here, Lordship, in 23?
You're right.
There must be some suppression of
The
facts either there
Point
or
of
here.
time in which it was.
Yes.
That was.
Let us call for the records
Or both.
of both, but that will automatically mean that the impugned proceeding will not proceed further since the records will be here. We can also formally pass an interim order not to proceed, and we'll try to make an endeavor to complete the matter.
Yes,
this way,
Lord.
okay? Heard Ms. D. Ghosh, learned counsel for the petitioner. Full stop. The petitioner is aggrieved by initiation of proceeding in FT case number so and so, huh? Page 3, whereby the learned tribunal, by an order dated 6/10/2025, has directed the petitioner to submit the written statement. Full stop. It is the specific case of the petitioner that there was an earlier proceeding initiated against the petitioner at being, where do you get the date? Where you state in your synopsis?
Page 41 is the order, Lordship, wherein he is declared as not a foreigner.
Uh,
By order dated
by the-
12/7.
What is last line? Last line? Being FT Kamrup M DV first case number from the synopsis. Wherein the petitioner, wide opinion dated 12/7/2023, has been declared to be not a foreigner. Full stop. It is submitted that the impugned reference presently before the learned FT Gwalpara is not maintainable in law. The aforesaid submission has, however, been vehemently opposed by the learned counsel for the respondents. and has submitted that it is the duty of a proceeding to prove that he or she is not a foreigner in a reference. Para? The issue which will arise, determination, would require some deliberation. Para? Let notice be issued, returnable on 15th of June, 2026. Union of India, Madam B. Sharma, Union of India 1, CGC. State of Assam, Home, A. Verma, Mr. A. Verma, 2, 6,
2 and 6 Lordship.
and 7 also perhaps,
267.
267. Then Election Commission of India, Miss S. Kotoki, Standing Council R3. And State Coordinator, 4, G. Sharma, Standing Council NRC 4. Then P. Sharma, State Council 5. Extra copies, huh? Then para, call for the records of both the cases, namely give 1 and 2. That Kamrup case, then Golpara case, huh? Then you write registry to issue necessary requisition. Para. Miss Ghosh, the learned counsel prays for an interim order, which is however opposed by the learned counsel for the respondent. Para. Considering the facts and circumstances and by balancing the equities, it is directed that till the returnable date, further proceedings in FT case number students of Golpara, shall remain suspended.
Deeply.
The aforesaid interim order would, however, be reconsidered on the returnable date upon instruction of upon receipt of instructions.
Wait, my lord, I referring to page 22, my lord.
This year has come.
Impin order, my lord. Yes, my lord, here has come. So, my lord, I want to point out one thing. I checked the LCR. But here, my lord, in expletive order dated passed on 24/2025. It is reflected in page 22.
It's an expert order.
Expletive order. My lord, that order is not in the record. That is why, my lord, LCR was called for to ascertain. That order is not available.
How come?
My lord.
The impugned opinion has to be a part of the record.
My lord, part of the record that is not there.
Where is the, which page? Which page of your petition?
My lord, by 22.
22.
22, my lord.
28 April.
The expletive order dated 24/2025. If we check the record, my lord, it is found that an order was passed expletive on 16/4/2024 on the record, my lord. LCI.
Now see, you are here, you are not challenging the initial order. You are challenging the order of 13/8/2025, whereby your application.
That's all,
for
that's all, my
review
lord.
has
That is
been-
why your lordship on earlier occasion pointed out to me that Mr. Sheikh, you placed this 24/2025 order. I approached the tribunal, my lord, applied for certified copy. Certified copy I have got, my lord. But in that certified copy, that order dated 24/2025 is not available. Then LCR was called for. to ascertain whether there is an order.
Hmm.
From the LCR also it is found that on 24/2025, no order is passed.
But why did you then file a petition 1 of 2025 to vacate ex parte order of 24/2020? Let us see your application. Let us see your application.
My lord, in my application also that that order has been challenged.
Then
my
it's your issue. You have
My
given
lord.
the date.
My lord. Your lordship would be pleased to see my petition, my lord.
Yes, your petition is at page 18.
Page 18, yes.
There may be a mistake in the date. We'll take care of that.
16/4 months. Maybe, my lord, it may
No,
be.
this is your written statement. Where is your application page?
Page 18, my lord.
No, 18 is your written statement.
Petition to court.
Application to vacate ex parte.
Yes. my lord. Annexure 18.
Please carefully go through the page.
My lord, I could not get that petition, my lord, that is in record, my lord.
Okay. We'll
That
see
is-
what have you stated in your petition.
My lord,
Maybe you have stated 24.
my lord, my lord.
So
My lord, that is
therefore
there.
Tribunal has stated that we cannot review
My lord,
24.
thing is
it
this,
barred
my
by
lord,
time.
there may be, my lord,
But
there
we'll
may be,
take care of- we'll take
there
care
may be
of-
16/4/2024, my lord. In my petition, I have written wrongly, and that
Therefore-
has been reflected in the
Take care
order
of that.
also.
We'll take care
Yes,
of
my
that.
lord. So, my lord, my humble submission before your
First,
lordship
let
is
it
chance
be
may be given
First,
to
let it be ascertained.
my lord,
First, let it be ascertained.
ascertain from record, my lord.
Madam, two aspects you'll have to check. First, when was the ex parte order? Number two, what date has been written in the application filed by the petitioner to vacate ex parte? Maybe there is some error. So that will take care of. Then we'll come to on the merit substance of the case. If he is praying for a remand to contest the case, what are the grounds on the first order regarding proceeding ex parte? Did he contest or did he neglected to appear or service was not done?
Lordship, paragraph 12.
Okay. Okay, we'll take a break for 5 minutes. Please go by the records. Go through the record.
Problem.
Yes, have you examined?
Lordship. There are two ex parte orders, Lordship. Three. And that has not been stated in the petition.
Oh. And the original proceedings of 16 FT case.
Yes, Lordship. 16 is 1444, one is 1442. And we could find two ex parte orders by now. There's one more.
What are those?
Lordship, just a moment. Just looking. 142.
কোন তারিখে order dated?
The order is not, the order is there in a separate sheet, and that is at page 97.
Of the records.
Order of records, Lordship. Page 63 is a order saying that the matter was fixed for ex parte, order in separate sheets. And the order is at page 97, Lordship. And then
Now, what about the aspect of service of notice? Was it served?
She appeared
Or neglected to appear?
Again and again, done expertise lordship.
twice ex parte.
My lord, the earlier expertise were vacated, my lord, but last one is in existence.
Lordship.
So my lord, I have filed written statements.
First one vacated, yeah. It was 865, which one was? Vacated, but still not, still not appearing, lordship. Two ex parte orders are there.
My lord, those were subsequently vacated.
Then we dispose of this matter, hear this properly. If there is continuous non-adherence to the orders, we may not find favor with the petitioner. Let us hear the entire matter. Yes, what is it about?
My lord,
Not on the merits, only on the part of expertise.
my lord, I do not have so strong case, my lord.
No, that is what.
My lord,
We are not
only
going
thing
on-
is this, my lord,
We are not going into the merits.
my lord,
We are only on the aspect of expertise, whether it's a matter which can be remanded back.
my lord. So my lord, actually, my lord, on the ground of expertise, my lord, only thing is this, my lord, a last chance may be given by your
But
lordship.
there will be two expertise. It
My
cannot be an unending process.
No, my lord, not unending process, my lord. Earlier, okay, earlier
Give
orders
the dates, give the
not
dates.
in existence, my lord.
Give the dates.
That were vacated. That were vacated. That is reflected in record only on this last one, my lord. Either it's 16-4, expertise order 16-4, my lord. Others are not in existence, my lord. Otherwise, it would have been reflected in the order, my lord. It is not reflected in the order.
Present order either 16-4 or 24.
16-4 or this 204, 2025.
16-4.
That's proceed by the number 1 of the 2025.
Yeah.
So, my lord, that was my query, that whether that is
16
2024, 2025 record is available.
Or
And petition, it was challenged for vacating the ex parte order lordship by petition number 1 of the 25 filed on 28/7/2025.
My lord, my submission was before your lordship.
Okay, we'll
that
come to you. Let
My-
us
my-
have the records.
Whether
See,
that,
the petition was dated
Petition dated lordship
1 of
2025, dated 28/7/2025.
for 28/7/28
Yes, lordship.
for
For vacating the ex parte order dated, here it was wrongly typed lordship, not 24/2024, it should be 16/4/2024. Procedure wrongly typed it, lordship.
then what happened to that case petition?
Lordship, prior to that lordship, on 28/9/2022, here is another ex parte order. That's not a lordship. It was also vacated lordship. After that, again, this ex parte order was passed, lordship.
When was it vacated?
It was lordship, date of earlier ex parte order date was 28/9/2022.
When was it vacated?
This vacated on lordship. It was
You are in detention.
no, my
Where are
lord,
you?
I'm
You are
not in
not
detention. I am a lady, my lord, I am outside.
by 6/12/2022, lordship, it was vacated and proceeding was directed to file written statement. Accordingly, she filed written statement, lordship. 6/12/2022, earlier ex parte order was vacated, lordship. 28/9/2022.
Thereafter WS.
Then WS, lordship, WS was filed on
It was filed on 19 July 23.
Yes, Lordship.
But you are taking everything for a ride, Mr. Sheikh. The first exporter order was vacated on 6/12/2022 with a direction to file written statement. You filed written statement after 6 months, 19/7/2023.
My lord, I cannot dispute anything, my lord, what is on record. But thing is this, my
So
lord,
are you entitled
if
to
your
any?
lordship, my lord, I am leaving to your lordships that I am a lady, my lord, having children. That if possible, my lord, a last chance may be given, a chance, last chance. Thereafter, my lord, if she defaulted, my lord, there should not be any indulgence to that.
Oh, have you filed your evidence on affidavit?
No, my lord, a written statement filed, my lord, evidence is not filed. So, my lord, a time may be framed, a last chance may be given, and it may be recorded in the lordship's order that no further time will be granted.
She's got minor.
My lord, minor children, my lord.
Where have you stated? What is your age?
My lord, my age I am giving, my lord. It's 46, my lord. 46
46.
years.
Where is the description about the children?
My lord. My lord, children I have not stated in the writ petition, my lord, but I have.
No,
I am a
not-
married
not-
person, your
not-
lordship.
Not stating will not do.
My lord,
You have to state it.
my lord.
If
I
you
have
are-
not,
If
you
you are
have not-
seeking equity, you have to state.
I have not estimated, my lord, stated. Brothers, sisters, I have stated.
The chronology of events are not encouraging at all. See, this proceeding started in the year 2016.
My lord.
The first ex parte order was in the year 2022.
My lord.
You filed an application for vacating. After around 4 months, it was vacated on 6/12/2022, directed you to file a written statement. Written statement filed on 19/7/2023, after more than 7 months. Thereafter, again ex parte order, which was on 16/4. From 19/7 to 16/4, almost 9 months have passed.
My lord.
Then you filed application when? After, in the year 2025, on 28/7/2025, more than a year in a contested petition.
My lord, what is on record, my lord?
That you cannot
I
say.
am not disputing, my lord.
Mm.
I do humbly submit before your lordship. I am leaving to your lordships. If possible, my lord, a last chance may be given to me. I have taken time, my lord, no doubt. I am fairly submitting before your lordship that actually I have taken time, that the petitioner is not sincere. But thing is this, my lord, I have before your lordship on the ground that last chance, if possible, my lord. A time frame may be given, my lord, a last chance may be
Cannot be
given.
possible. Otherwise, we are very lenient in ex parte
My
vacating.
lord, my lord,
But here it may not be possible.
my lord.
May not be possible.
Since 5/8/2022, Lordship, she is appearing, Lordship. And WS was filed in the year of 2023. After that, again, expertise.
My lord, your lordship will consider that the lady, my lord, the lady, my lord, illiterate lady, is not a complicacy of law. He is not aware of this. My lord, a short date may be
She
given.
is
my
not illiterate. She can write her name.
lord. Only, my lord, she can write the name.
She may not be educated, but
My
she is
lord,
not, she is
not
not
educated, my lord. She
She
is
may not be
actually,
educated. She is literate. She can write her name.
my lord, his father, my lord, is an Afghan origin person. He married here and livelihood started here, my lord, in this way. His father name was Adam Khan. And another thing your lordship will consider against his mother, my lord, and the other family members, no case is there. No. They are also here in the country. My lord, I have mentioned the sisters, my lord, the brothers, my lord. Against
You may
nobody.
not be entitled to equitable relief.
My lord.
You may not be entitled to equitable relief.
Not, may I submit one thing, my lord?
Yes.
Honorable Supreme Court, in some cases, held that if against other family members, there is no reference, that in that case, my lord, his case should be considered, because why not other person, she is particularly Susan. Mother is there, my lord, that her brothers and sisters are there, my lord.
That cannot be a reason. Rather, we are on a more lenient view that one reference against a family member cannot be used solely for other members unless there is specific reference.
Well, that's all right, my lord, but a last chance may be given, my lord. A short date may be given, my lord, from birth, my lord.
Your conduct is
My lord,
absolutely
I
discouraging.
do agree, my lord. I do agree. I
No,
may
no.
be excused, my
Sir,
lord. I do
dismiss this,
agree
please
that
dismiss.
my conduct is not proper. But
Dismiss.
my humble submission before your lordship, I am in India, I born in India, I am living here, my lord. Even if I remain here for 3 months, my lord. Say, my lord, your lordship granted me 3 months' time. I remain here for another 3 months' time, my lord. My lord, no wrong will be committed, my lord. Let me give 3 months' time, my lord. Not more than that. Within 3 months, my lord, I will appear and contest the case. If
He was born in
this,
1979.
my lord,
79.
my lord. So, my lord, my humble submission before your lordship is this: 3 months' time may be given. I will appear. Written statement is already there, my lord. I will file affidavit.
In the written statement, there is not a single document which you have enclosed.
My lord, that is there.
That also, that
That is
aspect also we have seen. Prima facie, you are not making out a case.
My lord, anyhow, my lord, it is an expertise order. Just I am on this expertise. If the honorable tribunal, my lord, after 3 months decided that I am a foreigner, then matter will end there. So, my lord, only 3 months time may be given.
No,
I am not
that-
asking
that-
for more.
That is nothing exceptional. That we are doing for every case.
My lord, only.
We are only
My
saying
lord,
that 314 we have been
my
referring.
case is this, my lord. My case is this, my lord. I born in India. I am in India for a long time, 46 years. Now case has been started, my lord. Let me remain for 3 months, my lord. Let me remain in 3 months in
Okay,
this.
we have heard you. We'll dictate the judgment in the
My
open
lord,
court.
my lord.
The instant application has been filed under Article 226 of the Constitution of India, challenging an order dated 13/8/2025, whereby, please have your seat,
My lord.
whereby the learned Foreigners Tribunal 7th, Sonitpur, has refused to vacate the ex parte order dated 24/2025 in the connected so-and-so case, Balipara, connected FTDC 1442 of 2016. Para. At the, we have heard three MSC, Learned Counsel for the petitioner. We have also heard, Madam, where have you disappeared? You're hesitating to appear, why? Also heard Ms. A. Verma, Learned Standing Counsel, whom, Shri Sheikh, the Learned Counsel for the petitioner at the outset has submitted that though the impugned order dated 13/8/2025 has referred the ex parte order date as 24/2025, the same should be 16/4/2020, no, 24/2025, 24/2024. In your synopsis also you have written 25. 24/2024, the same should be 16/4/2024. Full stop. This aspect has also been verified from the original records which have been requisitioned by this court, wide order dated 25/3/2026. The Learned Counsel has submitted that there was that he has also that the petitioner has also filed her written statement on 19/7/2020 written statement, and one chance be given to her to contest the proceeding. Full stop. On the other hand, comma, Ms. A. Verma, the Learned Standing Counsel, has submitted that the petition has been filed with suppression of material facts. Full stop. She has submitted that the records would reveal that the proceeding, which is of the year 2016, had culminated in an ex parte order dated 28/9/2022. Full stop. However, there was an application to vacate the said ex parte order, which was accordingly done on 6/12/2022 with a direction to file the written statement. Full stop. Thereafter, the written statement was filed on 19/7/2023. Full stop. It, however, appears that the petitioner had again neglected to appear and contest the proceeding, leading to passing of the order dated 16/4/2024. Full stop. The said order was sought to be vacated by filing petition number 1 of 2025 dated 28/7/2025, which has been rejected by the impugned order dated 13/8/2025. Full stop. It is submitted that the petitioner has willfully and deliberately neglected to contest the proceeding and no equitable relief. And accordingly, she is not entitled to any equitable relief. Para? The written submissions have been duly considered and the materials placed before us, including the records of the tribunal, have been carefully perused. Puts the para. At the outset, comma, we are aware, we make it outset, we would like to put on record that in matters of vacating ex parte order, comma, normally this court takes a lenient view full stop. At the same time, we cannot be oblivious of the fact that the jurisdiction exercised by us under Article 226 of the Constitution of India is an equitable jurisdiction, wherein the conduct of the party approaching this court is of paramount importance. Full stop. Para. The records would reveal that there was an earlier ex parte order dated 28/9/2022. Full stop. It further reveals that the petitioner had filed an application for vacating the ex parte order, which was accordingly done on 6/12/2022 with a direction to file the written statement. Full stop. It, however, transpires that the written statement was not filed immediately and was done after a period of more than 7 months on 19/7/2023. Full stop. The full stop. Para. Thereafter, the petitioner had again neglected to appear before the tribunal and violated the order dated 16/4/2024. The learned tribunal has passed an ex parte order. Full stop. The said ex parte order was thought to be vacated by filing petition number 1 of 2025 after a period of 1 year, 3 months. That is on 28/7, more than 1 year, more than. That is on 28/7/2025. Full stop. The learned tribunal has accordingly passed the impugned order dated 13/8/2025, refusing to vacate the ex parte order. Full stop. Para. We have seen that the proceeding is lingering since the year 2016, and in spite of repeated chance given to the petitioner, chance an adequate opportunity given to the petitioner, comma, she has neglected to contest the same. Full stop. We have also seen that when the petitioner was aware of the proceeding, comma, the petition number 1 of 2025 was filed on 28/7/2025, which is more than a year after passing of the order dated 16/4/2024. Para. The learned tribunal in the impugned order dated 38/2025 has rightly taken into consideration the requirement of filing a petition within a specified time to vacate ex parte order, full stop. The Foreigners Tribunal orders of 1964, more specifically, Order 3/14, also mandates that a proceeding is to be completed within a period of 6 months. 60 days, full stop. Taking into consideration all the facts and circumstances, comma, we are of the opinion that the petitioner is not entitled for any equitable relief from this court. Para. The writ petition is accordingly dismissed. The records be sent back.
Obligation.
Yes, madam.
Lordship, it's an ex parte order. After filing written statement, Lordship, the petitioner could not file her, adduce her evidence and all, Lordship. She has all the relevant documents, Lordship, to prove her said.
This proceeding is of which year?
2017, Lordship. And
Agree.
yes, order is of 14/11/2017. Thereafter, in the year 2019, she was arrested. She was in the detention camp. And as per the Honorable Apex Court order and also of our Honorable High Court, she was released because she had completed 2 years. Subsequently, on 5/5/2025, Lordship, she was.
Yes, please.
And when she was, because every week she has to visit, as per the condition of that release, Lordship,
Yes.
she has to visit the local jurisdictional police station. So on 5th was the day, 2025, when she appeared, and thereafter she was being sent to the detention. And I'm appearing here as a legal aid counsel, Lordship.
Now, what is your challenge?
Challenge is an ex parte order, Lordship, 14/11/2017, Lordship. So she is a widow. She has only one daughter.
Page.
Page is Lordship, page 31, Lordship.
Beautiful. IA for?
I for release from the detention, Lordship.
Which page?
Page 31 is the order, Lordship. Impaired order, Lordship.
31.
Yes, Lordship.
Mm.
17 order, Lordship. Her plight is that she is a widow, Lordship. Her husband died in the year 2005. I have annexed the death certificate also, Lordship, of the husband. She has all the relevant documents. At least if one chance is provided to her, she can contest the case, Lordship. And all the relevant documents I have annexed along with the writ petition, Lordship.
Yes, what can be done? 17 is the opinion, 14/11/2017.
Yes, Lordship.
The learned tribunal has recorded the aspect that WS was filed on 22/3/2017.
Hmm.
Thereafter, the matter was adjourned on your behalf on 3 occasions by filing petition.
Yes, Lordship.
And after those petitions were disposed of and time was granted, you had thereafter failed to appear and did not even take any steps.
Yes, Lordship.
So those considerations are relevant consideration.
Yes, Lordship.
So-
It's,
But on the other aspect, that you had filed, you are saying that you had filed written statement, there are positive evidence which you'd like to reduce.
yes, Lord.
But the issue which would arise is this opinion is of 17,
Yes, Lordship.
number 1. And what happened? You were taken to detention.
Yes, Lordship.
When?
5/5/2025, Lordship.
5/5/25 detention.
Yes, Lordship. And I was released prior to that also in the year,
When?
I was released, Lordship,
When were you taken to detention?
earlier in the year 2019, Lordship.
2019,
Yes, Lordship.
petitioner detention.
Then, and annexure 2, Lordship, page 33,
Yes.
I was released, Lordship, due to Honorable Apex Court order and as well as our High Court order,
They released on
released on bail, Lordship.
when? No, on date
Date 5/5/5/2021, Lordship.
5/5/21.
Yes, Lordship. And
Okay.
every month she used to appear regularly on 5th. So this 5th, last year, when she appeared before the concerned police station, she was arrested and she was not allowed to come back. And since 5/5/2025, again, she is detained, Lordship. And right now she is in detention. Matia Camp, Lordship.
Now that the initial detention, which was made in the year 2019,
Yes, Lordship.
that ended with a release order of 5/5/2021.
Yes,
And
Lordship.
again, why have you been detained?
Because every month she used to go for the surety and then last year that push back was going on. So most of the person who were released at that time and they have not challenged the order were detained. She has not challenged the order because during that time legal aid was also not provided to her. And this time legal
But
aid
they
is.
have approached this court in 2026
Yes, Lordship.
against an order of 17.
Yes, Lordship.
And it is not a case that you are not aware of the order, you are detained.
Yes, Lordship.
You have been released by Supreme Court's order, this court's
Yes,
order,
Lordship. Yes,
released in
Lordship.
21.
Yes,
And
Lordship.
unless you are, until you are detained again on 5/5/2025,
Yes,
you do
Lordship.
not take any steps against the ex parte order.
Yes, Lordship, because she is a poor lady, Lordship. She didn't have enough money to before the learned tribunal. This is the reason, Lordship. If she would have been provided also legal aid during the detention period 19 to 21, at least she would have before this honorable court, Lordship. So she thereafter, once she received legal aid, only through legal aid she is before this honorable court, Lordship. Only one humbly I'm praying, only one chance, Lordship, and relevant, all the documents are there, Lordship. And she is in widow and she doesn't have any son, only one daughter who already got married and she is also not earning. She is also dependent upon her husband. So where from this poor lady, she is an old age person, Lordship. So to find.
No, those aspects are there, but the other aspect of dealing with foreigners, that is also very important.
Yes, Lordship.
We cannot be swayed by the fact that some foreigner is
Yes,
economically deprived. We have to balance it.
Yes, Lordship. Yes, Lordship.
If had it been a citizen, all sympathies for you, not for a foreigner.
Yes, Lordship. Her misfortune is her poverty, Lordship. If she would have been able to afford the litigation expenses on the first round itself, Lordship, she would have sufficed that. She has all the relevant documents, Lordship. 66, 60, 70, then 75, Lordship. All the documents are there.
No deportation also. 2017.
So, my lord, what happened, my lord? This case, it is not that, my lord, she did not receive notice. She received notice, she filed her written statement. She deliberately, my lord, avoided the court procedure, tribunal procedure.
Now she has been declared foreigner on 14/11/2017. She was not, she was arrested in 2019. But in 2019, when my lord she was arrested, the Honorable Apex Court has said those persons who could not be deported due to some reasons and who have been there in custody for more than 2 years, they may be released on bail. And during COVID period, this Honorable High Court also said, due to COVID pandemic, these persons may be released who are in detention. On those conditions, she was released in 2021. Now, from 2017, 2019, my lord, even during proceedings, she did not appear, that's enough. Another aspect, my lord, for 2017 to 2009, she did not dare to silence the, my lord, the opinion. Even after, my lord, release in 2021, still in 2025, she did not dare to silence the opinion, my lord. Now, in 2025, when the state government has taken initiative to deport these persons who have already been declared foreigner and whose opinions are not silenced, my lord, the deportation process was initiated. When deportation process was initiated, all those persons who has not silenced those opinions, they have been detained and they were supposed to be deported. But they have been, then only they are coming this, my lord, by filing this petition. Had there been no matter deported, arrest, again in 2025, she would not have come. She was hiding at home. So obviously, my lord, we are saying, my lord, the right of the petitioner is concerned, definitely, but it cannot be endless proceeding. This Honorable Court has numbers of occasions said, but only one line I'd like to.
Deportation must be registered, that is understand.
Yes.
It's understandable, but the process of law should not be defeated.
Yes. In 2016, 1 GLT 273. 2016, 1 GLT 273.
2016.
2016, 1 GLT 273, my lord. Ayub Ali and others.
AYUB.
Yes, ma'am. Ayub Ali and others. Versus Union of India.
Hmm.
There in my lord, the single judge order of this High Court was upheld by the division bench.
This is the review order.
Yes. Read appeal order. Read appeal. In para 13, subpara 16, I would like to rely.
1316.
Yes.
Name of the case.
Ayub Ali.
Ayub Ali. What the Honorable Court has says, principle of natural justice cannot be put into a straightjacket formula. It is more than 3 decades that the issue of influx of foreign nation has been public domain in the state of Assam. Process of determination of questions of citizenship cannot be one-way traffic, leaning only in favor of the person whose citizenship is doubted. Interest of the state is also a paramount importance in the unabated influx, has the potential to affect the integrity and sovereignty of the country. Citizenship of a person, no doubt, is a very valuable right and should be jealously guarded. However, if a person does not take steps to safeguard his interest, he does so at his own risk.
peril, yes.
Own peril. Right of fair hearing and principle of natural justice cannot be permitted to lead to a farcical situation. Farcical situation and to be an engine to defeat the very object of the identification and deportation of the.
That is our view also.
Yes.
We are fully in
That is the
agreement.
That is the view taken by this Honorable
We have to
Court.
balance, and while balancing, the interest of the state cannot be lost sight of. It's of
That-
utmost importance.
Yes, the facts and circumstances here in this case, madam, it's the same. She has taken her own risk. She has not even cared to, madam, silence the opinion. It is not the case that she did not receive notice, madam. Had there been no notice, that was a different. In that case, it was a different case. But she received notice. She filed at WS. Deliberately, she did not appear thereafter.
Can we see the written statement here?
Yes, the written statement is here.
Written statement is at page 34, Lordship.
Where is the impugned order?
Impugned order is at page 31, Lordship.
You had a counsel before the tribunal.
Yes, Lordship, because I could not arrange for his fees for evidence. This is the reason he did not appear for evidence and.
No, he
my-
was there in the hearing also.
Yes, initial WS was filed and thereafter, because in three
Instead of
occasions,
non-payment of fees, he was there present representing you when the impugned order of 14/11/17 was passed. Mintu Nath.
yes, his name is reflected because he has filed the WS. His wakalatnama was there, Lordship. So his name is reflected, Lordship. Because he did not take adjournment on one occasion. Thereafter, it was fixed for ex parte order, Lordship.
3 adjournments granted.
Yes, 3 adjournment
And
granted.
but thereafter, non-appearance without steps.
Yes, Lordship. That day he did not appear, Lordship. My humble prayer is if she would have been provided legal aid in the year 2019.
We
when
cannot
she-
extend the equitable jurisdiction in all cases.
Yes, Lordship, that I can understand. But the plight of a woman, widow, Lordship, her husband died. She don't have any son.
Widow, obviously, husband died, then only she become
So,
widow.
yes,
Where are you
Lordship.
saying that widow because of the husband has died?
Any independent income, Lordship. She lives on begging, Lordship, and her only one daughter, that also she got married, Lordship. And she is also not earning. She is also dependent upon her husband, Lordship.
We will not be swayed by this kind of submission, madam. You
Yes,
make
sir.
submissions
I'll
on
leave up
law.
to Lordship.
Don't make this kind of submissions.
Yes, Lordship. I'll
Poor
leave up to-
petitioner, this petitioner. You make submissions on law, we'll consider.
One genuine
on the next 4 dates, namely 25/2017, 28/6/2017, 19/7/2017, and 5/10/2017. Full stop. However, on the next date, that is 27/10/2017, the petitioner was absent without steps. Full stop. Accordingly, the impugned order was passed on 14/7/2017 ex parte against the petitioner. Full stop. It also transpires that from 2017, it also transpires that the petitioner was taken into detention in the year 2019 and was released on 5/5/2021. And in spite of such release, no steps were taken for filing any petition for vacating ex parte or approaching the appropriate forum, full stop. It is only after the fact that the petitioner has been taken into detention again on 5/5/2025 that this petition has been filed, full stop. We have taken into consideration the submissions advanced by Sri Payeng that the instant writ petition has been filed when certain process of deportation has started, full stop. We have checked from the records that the present petition has been filed on 17/3/2026. That is after a period of more than almost about 9 years, full stop, 9 years, full stop. It is also not the case that the petitioner was unaware of the impugned order dated 14/11/2017, with the aspect regarding the individual right of a proceedee vis-a-vis the interest of the state, we are in full agreement with the observations made by this court in the case of Ayub Ali Supra, which have been extracted above, full stop. We are of the opinion that the jurisdiction exercised by us under Article 226 of the Constitution of India is equitable in nature, and the conduct of the party approaching this court becomes of paramount importance, full stop. In the instant case, we are of the opinion that the petitioner is not entitled to the equitable relief, and accordingly, the writ petition stands dismissed. In view of the final orders passed in the writ petition dismissing the same, I stand closed.
Lordship, one submission was there, mine was, on the last occasion when 19 to 21, her legal aid was, because this is also, I'm appearing as a legal aid counsel. That time, if she would have been provided with legal aid, then she would have been before this honorable court on due time, Lordship. Only in 26 and 29 January, the superintendent has forwarded, I have annexed that document also before the DLSA Goalpara.
Okay, we have dictated the order. Okay.
Lordships, may I humbly pray for it to be taken up after some time, Your Worship. Counsel is on legs in court number 7, Your Worship.
Who is the counsel?
Mr. SD.
Next one also.
Next one also, yes, Lordship.
Please ask him to come. Motion matters, we would like to issue notice.
Again, 14.
Wait, please, Your Lordships. Here in a case, my lord, there is a only one reference, but two proceeding is initiated by two tribunals, my lord. One proceeding was initiated by the Tribunal of Kokrajhar district, another by the Bileshwara, my lord. And in the Kokrajhar district, my lord, tribunal case was initiated earlier. Then, my lord, the second case was initiated by the Bileshwara, my lord. My lord, first come to page 43. This is
But you have come to the court, why so late? 2018 opinion.
because, my lord, this is the second proceeding, my lord, initiated by the Bileshwara Tribunal, my lord. After concluding, my lord, evidence, my lord, he did not visited the court of Bileshwara, my lord, and he pursuing the case at Kokrajhar, my lord. And subsequently, the Kokrajhar case was ended, my lord, 106, my lord, in the year 2023. And the petitioner was, my lord, declared as foreigner in between 1966-70 on stream, my lord, and directed
But
to,
this impugned opinion, is it ex parte?
no, my lord,
Then you had contested the proceeding.
contested the proceeding, my lord.
And what happened to the Dhubri case?
In Dhubri case, my lord, declared as foreigner, my lord, stating that, my lord, the petitioner failed to establish his linkage with his parents, my lord.
That opinion, is it challenged?
Yes, my lord,
Where?
now challenged, my lord.
This-
Here challenged, my lord.
And Bilasipara?
That Bileshwara is challenged in this case, my lord. And whereas, my lord, the petitioner name is appeared along with
And the
his
Kokrajhar proceeding?
Kokrajhar proceeding, my lord, declared as foreigner in between 1966 to 71 stream and directed to register, my lord, under section 6A.
You have not challenged that.
Annex here, my lord.
You have not challenged that.
No, my lord, I have not challenged.
You are satisfied with that.
Already, my lord, registered his name, my lord.
No, you are satisfied with that, the Kokrajhar opinion.
Since not challenged, my lord, satisfied, my lord. And in the present proceeding, my lord, the court himself is doubt, my lord. First, my lord said, my lord, he is failed to establish link with his parents.
2018. Why are you so late? Yes, Mr. Sharma? On the merits, we'll hear you on the appropriate time, but on the aspect of gross delay,
Opinion is that.
Yes, my lord. Impugn opinion, my lord, started from page 74. And operative part, my lord, page 76. Court himself.
yes.
Letter by opinion by which he was declared as a stream foreigner in between 1966 to 71 birthday.
Yes.
So it was passed in the year 2023.
Yes.
And earlier opinion was passed in the year of 2018. So, Lord, see, I think of it. Proceeding has to establish proceeding has to place the earlier order before the concerned tribunal, lordship.
Yes.
Prior to, yes, lord.
But the Kokrajhar,
I think, lordship, it was suppressing this order, lordship. He can able to get this letter order, lordship. So
My
it
lord.
was placed or not, that was executed or not, I don't know, lordship. I have to check the record.
Okay.
and in the inquiry report, my lord,
Okay, let us issue notice at this stage.
Lordship.
Third, your M. Hussain.
My lord.
Third, Sri M. Hussain, learned counsel for the petitioner, who has put to challenge an order dated 30/8/2018 passed by so-and-so in so-and-so, declaring the petitioner as foreigner post 1971 Supreme. It is, amongst others, it is contended that out of the same reference, there were two proceedings, and in the other proceedings before the Foreigners Tribunal Kokrajhar, the petitioner has been declared a foreigner in the stream of 1966 to 1971. Para. On the other hand, 3 G. Sharma, Learned Standing Council, FT, has submitted that the opinion of Kokrajhar is of the year 2023, and it appears that the impugned opinion of dated 38/2018 was not brought to the notice of the said tribunal. Para. Be that as it may. No. He has also issued the, he has also raised the issue of delay and laches and has accordingly questioned the maintainability of the writ petition.
Yes.
Para. Let notice be issued, returnable on 17th of June 2020, not 17th, 15th of June 2026. Union of India, B. Sharma, Miss B. Sharma 1. Chief Election Commissioner of India, S. Kotoki, Miss. State of India, State of Assam, Chief Secretary, Madam R.B. Bora, 3. Then the Home Department, G. Sharma has 4,
4,
5,
7, 8, 9.
7, 8, and 9. And in R.B. Bora, 2 Lekiba. 3 and 6, DGP. Madam, DGP also. DGP will take. Mr. Sharma, DGP will take. But I want 3. Then Sharma will be for 4, 5, 6, 7, 8, 9. And electoral officer? You will illustrate. Then 3 and 6 are we Bora. Extra copies. Call for the records. Office to give requisition.
Both the cases, the record may be called for matter, because since both the cases initiated from on.
At this stage will not. It's not a different process reference. We'll like to see the legality of this one.
And my lord, one more thing, my lord, the referral authority.
The maintainability of the writ petition is however kept open.
One more thing, my lord, the referral authority submitted the reference, my lord, stating that the suspect is not a foreigner, my lord. So, my lord, the tribunal has no jurisdiction to decide, my lord, against the reference, my lord. My lord, page 43 onwards the inquiry report, my lord. Page 43, 44. During inquiry, it is found that the suspect Gauhati Sheikh is not a foreigner, my lord. And the original, my lord, page 45. During inquiry, it is found that the suspect Gauhati Sheikh is not a foreigner. In the vernacular, my lord. Then, my lord, form 3 started from page 50, page 52. Forwarded to the Foreigners Tribunal Dhubri with the intimation that the suspected does not appear to be a foreigner, hence the case may perhaps be dropped. And vernacular, my lord.
Okay.
Page 54.
Yes, in matters of this nature, what do you do?
Yes, my lord. And there is so many judgment, my lord, in this regard, my lord. Tribunal has no jurisdiction, my lord.
Now we'll look into this
Yes, my
aspect.
lord.
There was no, was there any occasion to go ahead with the reference?
Yes,
There is no reference.
yes, Lord.
No. If there is a report that he's not a foreigner.
Tribunal can go beyond reference, Lord.
No,
Cannot.
that is okay. If reference was, if there was blank, it is not a blank. There is a clear-cut opinion that he is not a foreigner.
Lord.
Yes.
Okay.
What is there to be decided?
Tribunal.
Not a foreign.
Yes.
Okay, you look into this aspect.
Yes, yes.
This is something new we have found.
No, my lord, there is so many judgment of our High Court, my lord, since the referral authority submitted, my lord, the proceeding is not a foreigner or perhaps suspected may not be a foreigner, then the tribunal has no jurisdiction. My lord.
My lord, it is a deporter case, lordship, and if it is a deporter case, lordship, ERO's inquiry is there, lordship. If ERO done the inquiry, then police.
No,
authority
we have
cannot-
called for the records.
Yes,
Records will reveal everything.
Yes.
Okay, next.
I create, my lord, both the cases record may be called for, my lord.
If it is necessary, we'll call for.
My lord.
Mm.
Obliged.
2018 opinion.
My lord.
May it please your lordship, I apologize for not appearing when the matter was
Yes, what
called,
is it?
lordship. Lordship, I am challenging an ex parte order against me, lordship. My contention is that the notice was not served upon me and it was not served in accordance with the law laid down by this honorable court and also the foreigners tribunal's order, lordship.
What is the report of the Jari Karo?
Lordship, he has his report. I have annexed at page number 27 and the translation is at page 26. He
Please
served
read
it,
27. Please read 27.
লর্ডশিপ সমান সহকারে আপোনাক জনাও যে আমি আপোনাৰ নিৰ্দেশ মৰ্মে জাননীত উল্লেখিত গাঁও গৈ স্থানীয় ব্যক্তি তথা বিএলক সোধপোছ কৰি উক্ত ব্যক্তিজনৰ ঘৰ বিচাৰি পোৱাত তেখেতৰ ঘৰত গৈ তেখেতৰ ল'ৰাক জাননীৰ সকলো কথা বুজাই জাননীৰ বিষয় কপি দ্বিতীয় কপি চমজাই দি প্ৰথম কপিত স্বাক্ষৰ লৈ মহামান্য আদালতলৈ প্ৰেৰণ কৰিলো।
Notice was duly served.
So, Lordship, first is that the notice was in English, Lordship. It is at page 25. It is one, Lordship, the aspect is the name is not mine, Altaf Hussain, my name is Atalab Hussain. Secondly, your Lordship, the notice.
But your father is late Khabar Ali Sheikh.
Yes. Then the village is Bagheshwar. I am a resident of Fuhuratoli, which is a neighboring village, Lordship. Now, the elder son, Sairuddin, to whom the notice was served, Lordship, he is the eldest of the 8 siblings, Lordship. So around 8 years ago, he had moved out of that house and he lives separately around 3.5 kilometers away from the house of his father, Lordship. To that effect, I have submitted a report of the a certificate by the ward member who is of that specific ward, Lordship, which is at page number 28. Now, Lordship, the report of the service process server's report does not reflect that I was present at that house and it could not, or I am a resident of that house and I was not present, and that is why it was served upon the son of the petitioner, Lordship. And that is a precondition for service upon an adult family member of the family. In that regard, Lordship, if I may kindly refer to the FT order to 1964, Lordship, Foreigners Tribunal order. Lordship, under order 3, suborder 5B, Lordship. A and B, Lord.
Order 3.
Suborder 5, A and B, Lordship. Clauses A and B.
Yes.
3.5. First, 3.5A, Lordship. The notice shall be served at the address where the proceedee last resided or reportedly resides or works for gain. And in case of change of place of residence, which has been duly intimated in writing to the investigating agency by the alleged person, it shall be served at such changed address by the Foreigners Tribunal. If the proceedee is not found at the address at the time of service of notice, the notice may be served on any adult member of the family of the proceedee and it shall be deemed to be served on the proceedee. So, Lordship, the process service report does not reflect that I was not present at the home. He directly says I went to the home and I served it on the son and explained the contents of the notice to him properly. And the judgment.
ব্যক্তি ঘৰ বিচাৰি পোৱাত তেখেতৰ ঘৰত But this Sarijuddin is your son.
Yes, yes, Lordship.
And he says that he's son of Atalaf.
Yes. Atalab
So-
is the petitioner.
So there is no dispute with regard to the notice, whether it was sent to Atlaf or Atalaf.
Lordship.
And his signature is there at page 27.
Lordship. Now, Lordship will see the notice says village Bagheshwar. Now, if your Lordship peruses my documents, I have annexed my documents. This says my village is
No, those will
Fuhuratuli.
be besides the point. Once your son has accepted the notice,
It cannot be served on the son directly unless if I'm not there at the home, then yes, Lordship. That has also been laid down by this full bench of this honorable court, Lordship.
is there a finding that you are there?
No. Kindly
There's
see,
no
Lordship,
finding that you are there.
by
Why
the-
will the process server give notice copy to your son if you are there?
Exactly, Lordship. No, he gave the process servers ought to have recorded that I'm not there at home because that is not my home, Lordship. I reside separately. He's the eldest son amongst 8
So
siblings. as well.
what is the requirement of law under B? He is not found at the address at the time of service. Address is what last known. Your son is there. Son has been served.
Son resides separately, Lordship. He resides in a different house. And Lordship, he ought to have informed me, I agree, Lordship. But the notice was in English. He studied up to class 4. I have annexed his school certificate also. He did not comprehend what is the outcome and impact of this notice, Lordship. And he did not serve it
These
upon me.
submissions are very, very weak submission. Notices in English.
No, that is the
We
law.
we know that you are not conversant with English language, but you know what is the notice.
Lordship, but that is
Better than the lawyer, the client will know what is the notice of an FT.
But Lordship, if it had to be first attempted to be served upon me, if I'm not found,
This
then only.
this endorsement is sufficient. Why should the process server go to this house of your son who lives separately?
He's the eldest son, Lordship. He asked the local persons. He says the process server says this. I asked the
Process
local
server has
person.
gone to the address which was given in the records, not to the new address of the son.
Kindly see, Lordship, the notice is served at address to Bagheshwar village. Page 25. Page 25, Bagheshwar is the address.
What is
village.
the address in the reference?
Don't have the reference, Lordship.
But why from their own they'll write Bagheshwar?
But Lordship, the impugned order reflects village Bagheshwar. So Bagheshwar is the address of my son. Now, Lordship may kindly peruse my documents, including the voters list of 2005, Lordship, where my name appears.
No, we are
33
not,
onward.
not on the merits of the case. We are on the aspect of serving of notice or not.
Lordship, it was.
Whether can be deemed to be service of notice.
It was.
In spite of them, you have neglected.
My village is Fuhuratoli. They serve it at Bagheshwar to my son, Lordship. And although there is process server serves this to my son, he does not record that I am not present at home. If I am present at home, it has to be personally served on me, Lordship. And Lordship, may I kindly submit this judgment also of the full bench, Lord.
Where is the ex parte order? 26.4.
Ex parte order, Lordship, is at page number 17 onwards, Lordship. And the report by which the learned tribunal accepted the service of notice also I have annexed at page number 32.
See the number of dates. 1, 2, 3. 15, 16, 17, 18 dates.
Yes, I had never received the notice, Lordship. In the month of December, they came to apprehend me, and thereafter I came to know there is a proceeding against me. I took out the certified copies. They had come to me. I told them to take out a copy of the service report also. So there are on 2 occasions they took out the certified copies, and Lordship may peruse. In the Lordship, in the judgment of Muslim Mandal also, this honorable court had reiterated how the notice has to be served, Lordship.
This will be true. Yes, what do you say, Mr. Sharma or Mr. Payne?
It is clear. The only question was my learned friend is arguing at one point that he is not a resident of this Sipazar.
Bageshwar.
Bageshwar. He is a Bageshwar. But the entire documents, the reference, in fact, in the opinion also, the village is written as Bageshwar. And the notice is also in the name of Bageshwar. So as per the rules, it is said, or order, it is said the last resident. We cannot, if he does not provide the address, that he is shifting from that place, we cannot know that he has shifted from that address. So we have to serve in the
No,
last.
what is more intriguing is that the son had received the notice.
Yes, son.
But he is making a very fine kind of a submission that there is no finding recorded that the petitioner was not there and therefore the son was given. But this report,
Yes.
What is the implication of this report? Why will the notice be given to another adult member?
In absence of other male members.
In absence.
Member is present, he up to this. That is the implication. In absence of any other male member, the eldest member will have to receive the notice,
And his signature is there. He signs in English.
Yes.
Come to page 27. The day is trying to make a very wired kind of a submission. You're not aware. You are not required to know the language. Once you get the notice, you get all the advice.
No, Lordship, this honorable court has held in the full bench that the notice has to be in the official language of the state, Lordship. I have annexed my school certificate which shows I am a student of an Assamese medium school and I studied up to class 4. If I may kindly submit, Lordship.
The Assamese medium school student will not understand the notice in English.
Lordship, that class 4 I
You have to understand a judgment on the context. You are not an illiterate person. He signed in English language.
No, I understand, Lordship.
Then
in normal course,
can you put a law straitjacket without taking into facts and circumstances the background?
Proceedings of the FT are also there.
Lordship, 8 siblings in a house. Is it not natural, Lordship, for the eldest sibling to leave when he gets to marriageable age, Lordship? He's 24 years when he gets the notice, Lordship. It was, sorry, Lordship, he left the home at the age of 24. That is about 8 years.
He received this notice?
At his home, he received it, Lordship. The son, he received the notice, but that is not his father's home. He did not inform the father at that point in time. And it can only be served at the address of the proceeding.
This is an unbelievable projection.
If we see from 5A onwards, the notice shall be served at the address where the proceeding last resided.
Yes.
All reports is given. And notice is sent, page 25, notice is directed to be served at the village Bageshwar. This was issued on 9/4/2025.
Lordship, please see.
9/4/2021. Now, this notice is received on 3/5/2021. After the notice is served. So it is not that knowing that the son is residing there, the notice is issued freshly, and this notice is served on that particular day. The notice was issued on 9/4/2021. It shows, that because records are not available here, it shows that from the record, his address is Bageshwar. Address of the proceeding is at Bageshwar. Otherwise, notice should not have been served to the Bageshwar.
No,
reference should have been in Bageshwar. So if your lordship may want to see that, your lordship may call for the record for the time being. If we see is the resident, is the notice is the original reference is of Bageshwar, no question, no case may come. if the reference is of Bageshwar. If the reference is of a minority address which my learned friend is saying, present address.
Fuhuratoli. No, Lordship, the reference says it is of 2006. 2005 voters list I have annexed at page 35. Please see my address, Lordship, there. It says Fuhuratoli. My voter I card and Aadhaar card are there saying Fuhuratoli, but 2005 voters list also says Fuhuratoli, Lordship.
Also that matter, whether a person may residence and last residence, whether my lord, on the date of my lord inquiry, if the person was residing in a particular place, the notice has to be served in that place. On the next day, he may shift that place away. We don't. So,
And there is also a caveat
yes,
in 5A that if you change your address,
you have to
you're
inform
bound to inform.
the police officer, investigation officer. That is specifically given in there. That's why I wanted to see my lord the reference.
And Lordship, kindly produce these judgments for once, Lordship. Just one judgment.
Let us issue a short notice call for the records.
Yes. That. Okay.
Heard Sri S.J. Learned Counsel for the petitioner who has filed this application under Article 226 of the Constitution of India, challenging an order dated 26/4/2022 passed by so and so in so and so, whereby the petitioner has been declared a foreigner post 1971. Full stop. It is contended that the opinion has been passed ex parte. Full stop. Para. On the other hand, comma, Sri J. Payang, Learned Standing Counsel, Home Department, has submitted that from the materials available on record, including the report of the Jari Karak and the enclosure thereto, comma, it appears that the notice was duly served on the son of the petitioner, and this fact is not disputed. Full stop. He has also referred, in this connection, he has referred to the provisions of the foreigners within bracket tribunals, bracket close order 1964, more particularly order 3 within bracket 5 thereof. Full stop. Para to before you write J. Payam, you also write one more, huh? Sri Day has also, the Learned Counsel has also submitted that the notice has been served in the village, in an address in the village Bageshwari, whereas the petitioner's residence is at village
Fuhuratoli.
How do you spell?
Fuhuratoli.
Fuhuratoli, huh? Please check. Then Payang will come. As regards the submission on the address, comma, the Learned Standing Counsel has submitted that the address is taken from the reference, and in any case, comma, if there is a change, comma, the proceeding is required to intimate the same in writing to the investigating agency as per section 3, or not section, order 3 within bracket 5 within bracket small a. Para. To dispel any doubts on the controversy raised, comma, the records would be necessary to be perused. Full stop. Para. Let notice be issued, returnable on 15th of June 2026. Union of India B. Sharma, Miss B. Sharma 1. Home Political J. Payam for 2, 3, 2, 2 and 3. 5 State Coordinator
2, 3, 4, I can.
2, 3, and 4. And Election Commission of India, madam. You can write Eskotoki also, Miss Eskotoki. She was around only. Miss Eskotoki, Standing Council, ECI for file. Call for the records. Registry to requisition the same. On the next date, comma, this court would pass appropriate orders after perusal of the records. Yes, please. Item 13.
Lordship, item 13, she's the wife of the earlier petitioner, Lordship. In this case also, it was served at Bhageshwar, but this time the same two of the service process servers, one of them is the same as the earlier one. He says that he has no idea, he could not locate the petitioner, and he, although he went to Bhageshwar only, this time he hung it at the Gao Panchayat office, Lordship.
Okay, it was not served on the son.
No, this time.
This time we have a better case.
Yeah.
So earlier will be gone.
But kindly see, Lordship, same process server. This in the father's case, he went to the son's house. In the mother's case, he says he does not have does not know about the whereabouts.
But was it the same date? It wasn't the same date.
Different years, Lordship.
Different years.
Lordship.
Process server may be different.
No, same, Lordship. One of them is the same.
How does he know that he's the wife or some other reference 1 year back? Okay.
Lordship.
Third 3 as the learned counsel for the petitioner who has put to challenge an order dated 24/4/2019 passed by so and so in so and so, declaring the petitioner a foreigner post 1971. It is contended that the impugned order has been passed ex parte and a notice was not duly served on the petitioner. Let notice be issued. Rest all same. Let notice be issued. And respondents are the same, Mr. Dale?
Lordship.
You give extra copies.
Lordship is fixing a date.
We have given a date. Given a date, we've given what, 15th?
15th of June.
Both the matters.
The next one is of earlier managed in 2019. Probably at that time, it could not be traced off, but in 2021, it is traced off. The father is.
No, they say that the reference, it reflects the address.
Put, while you see, in the initial, don't put expert opinion, huh? You have challenged an order, then you said contended, it's an expert one. Whatever we have said. 15.
Much obliged. Lordship, can there be that the interim may be considered on the next date at least?
Next day, therefore, we have said appropriate orders will be passed. It may be an interim, it may be a dismissal.
Lordship. Much obliged.
Depending on the records. Okay. 15. Mr. S.A. Ahmed.
Sorry, my lord. May I please, my lord, this is expertise judgment, my lord. The judgment was passed, my lord, on 15/6/2012, my lord. 12. And
Why did you wait for some more
also,
years?
my lord, received the notice.
Huh?
She put her thumb impression on the, my lord, report. And she visited thereafter, my lord, she visited the court without, my lord, engaging any counsel, my lord. And one of the official asked her to put her signature on the register, my lord. Thereafter, she put her signature and left the court. And she, my lord, her impression was that my case is closed, my lord.
But we are not impressed with your impression. Not
My
at
lord,
all. This kind of impression, don't give it to the court. Tell something which is believable, trustworthy.
This is, my lord, the proceeding, she herself told me.
She herself told.
This is the condition. And otherwise, she has many documents.
She knows about all the documents,
Yeah.
but she doesn't know the proceeding. That she'll
Yes.
give a
Her
harm
impression
impression.
was that, my lord, that my case is closed.
But documents she is aware of.
And my lord,
There has to be consistency in your conduct. What is the finding, Mr. Payang? On ex parte?
This is
And why are you coming to the court now?
now, my lord, the police, my lord, frequently visited the house of the petitioner, but
Not yet taken into detention.
my lord, because of my lord, she has a, my lord, 14 years old baby, my lord.
Baby?
Baby, yes, my lord. Baby.
14 years?
Yes, my lord, 14 years.
Okay.
I shocked to see, my lord.
Okay.
My lord, she is, my lord, half feet length, my lord,
Okay.
only, and 90% disability, my lord.
Okay.
Because of that, my lord. Lord, I have annexed the certificate also.
But why have you come now? Because
Now,
police have gone to your place.
Disturbing.
So you should voluntarily do something without any push and pull. You have almost accepted the award. 2012, we are in 2026.
My
How
lord,
many
the
years?
Police personnel, my lord.
14 years.
14 years, my lord. Page 96, my lord. I have annexed the photo of the boy.
You have overstayed for 14 years.
14 years. Lord, page 96, my lord.
Yes, Mr. Payang, what to do? 12 years is too much of a time.
This is clear, my lord, that had there been no notice, if no notice was served, my lord, it was a different case. But notice was served. she
Notice
accepted
have
the notice.
received everything.
So there is clear negligence on her part. She
100% negligence
has
on her part.
taken own her risks by herself. So.
So we'll follow the order passed in the first half and dismiss it. You have neglected 14 years. An order of this nature, which has got very, very serious consequence upon you, you are not even bothered for 14 years.
My lord, kindly only see the, my lord, photocopy of the 14 years boy, my lord. Page 96.
That is a fact, but that is not a relevant fact for adjudication of this case.
Yes, ma'am.
This is a connected fact. We are concerned with relevant facts. Relevancy is receipt of notice, not receipt of notice, receiving by somebody else, hanging in some conspicuous place, not aware.
Yes, my lord. My lord, this is, my lord, she herself received the notice by putting her thumb impression.
So, same fate. The instant application under Article 226 of the Constitution of India has been filed challenging an order dated 15/6/2012 passed in case number so-and-so by the learned so-and-so, whereby the petitioner has been declared a foreigner post 1971, full stop. The primary ground of challenge is that the impugned order is an ex parte one. Para, we have heard Sri S.A. Ahmed, learned counsel for the petitioner. We have also heard so-and-so, no? Para, Sri Ahmed, the learned counsel, has fairly submitted that there is no dispute with the aspect of receipt of notice, which is a receipt of notice. However, when the petitioner had visited the tribunal, her thumb impression was taken in some register, and thereafter, due to ignorance, she did not contest the proceeding leading to passing of the impugned order. Full stop. It is also contended that the petitioner has got hardships, and by the recent visit of the police, she came to know about the impugned order. Full stop. Per contra, Sri J. Payang, the learned standing counsel, has submitted that the conduct of the petitioner in approaching this court after a lapse of about 14 years would itself demonstrate that she is not aware, she is not serious about the matter. Full stop. It is also submitted that the records would show that the notice was duly received by putting the thumb impression of the petitioner in the same. Full stop. The learned standing counsel has also referred to the foreigners within the tribunals order 1964, more particularly order 3 thereof, which also deals with the aspect of service of notice. Full stop. He has accordingly submitted that all these factors would that submitted that the above facts, and then from the above facts, the petitioner would not be entitled for any equitable relief. The impugned order has been carefully perused. Page 2. Where is which page?
Page 113, my lord. 113. Last
The
page.
order sheet the order sheet of the learned tribunal enclosed to the petition have been duly perused. Full stop. Notice was issued on 18/3/2010, and as observed above, admittedly, the notice was duly served. Full stop. On the next date fixed, that is 26/4/2010, the petitioner was in fact present, and in her presence, the next date fixed was 7/7/2010 for filing of written statement. Full stop. On the next date, that is 7/7/2010, the petitioner was absent without any steps, and 16/10/2010 was fixed for written statement. Full stop. The orders thereafter the translated copies of the orders thereafter have not been enclosed. Full stop. However, the vernacular however, the orders in vernacular have been enclosed, which would show that as many as how many dates? 7/7/7/7. As many as 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 dates were given, and ultimately, wide the impugned order dated 15/6/2012, the opinion was given declaring the petitioner to be a foreigner post foreigner, full stop. Para. Under section 9 of the Foreigners Act, so and so, the burden is upon a proceedee to prove that he or she is not a foreigner. Full stop. For any reference, the aforesaid provision is extracted here and below. Full stop. In the instant case, comma, there is no dispute to the aspect of service of notice. Full stop. What is also more relevant is that the challenge has been made in this court after a lapse of about 14 years, and the explanation given are not at all given, the explanations given do not inspire any confidence. Full stop. It is needless to reiterate that the jurisdiction exercised by us under Article 226 of the Constitution of India is equitable in nature, wherein the conduct of the party approaching this court is of paramount importance. Full stop. In the instant case, comma, the conduct of the petitioner in approaching this court is not beyond, is not above board, and there is gross delay and laches which is inordinate and unexplained and not properly explained. Para? In view of the above, the writ petition is dismissed.
Obliging. Yeah, please. Impugned opinion is page number, page 56, annexure K, Lordship, contested case, Lordship.
Date?
Date 25/11/2025, Lordship.
25. Okay.
25.
When did you approach? When did you file this? Okay. Yes, we notice, issue notice in this. He may be entitled to interim relief also. Heard 3 ABT Hawk Learned Counsel for the petitioner who has put through challenge and order dated so and so, passed by so and so, in so and so, declaring the petitioner a foreigner post 1971. What are your grounds, Mr. Hawk?
Lordship, three types of document petitioner submitted. One is land document of our father and grandfather, Lordship. One school certificate and
It is contended that there were documents to establish the linkage with the father and grandfather, which have not been properly considered. Para? Let notice be issued, returnable on 19th of June 2026. In India, B. Sharma means B. Sharma 1. Home Department, J. Payang 2.
And 3.
2 and, not 3, 2 and Election Commission, no.
No, 2 and 3.
3 is Election Commission.
3 is election.
2 and 5. 2 and 5. And then as Mrs. Kotoki for 3. We can record her name also. What is your name? MC now on behalf of S. Kotoki, standing counsel VCI for R3. Then District Commissioner, Madam R.B. Bora.
Yes.
4 and election officer also. 4 and 6 extra copies. Call for the records. Office to requisition the same. Then 3 Hawk, the learned counsel praised for an interim order. Pakis are not in detention, not in detention. That's okay. Next day, you appear on or before, Mr. Hawk? You appear on or before 22nd of May.
Okay. Some default is there, Lordship, at the time of filing. We have corrected also submitted, perhaps not defective is came to them. I will again.
You don't confuse your friends on the other side by giving some other copy.
Some error was there, Lordship.
What some error? Some other copy you have given.
No, everything is.
Of regularization of service of teachers.
In the cost title, some error. Otherwise, petition is same. Oblige, Lordship.
Good procedure. Emergency assembly. Mr. Sharma? Yes, sir. Is your matter urgent? What urgent?
This person is behind the bar, my lord. He has been
Petitioner is
There are
behind
many
the bar.
persons behind the bar,
No, not
above
really.
you.
He is, in some other cases, he was.
Mr. J. Ahmed's
case.
client is behind the bars. See, he has not even uttered a word.
But he is behind the bar for his younger brother, Lordship.
For his younger brother.
Younger brother, Lordship.
The issue here is, my lord, something. Is the, my lord, what happened in this case? I have the instruction that, my lord, he, as per, now he's coming that he's not the person. Initially in the case, my lord, when notice was issued, he appeared, showing him to be the same person. And he continued the
Oh, you are
proceeding.
very smart, Mr. Sharma.
Yes, he continued the proceeding.
When it is required, you become that person. When you are behind the bars, you do not become that person.
Continued the proceeding. We don't know, my lord, because he may not be the same. But he continued the proceeding for at least 2-3 years. Then on the date of opinion, my lord, he was there in the
Court,
tribunal.
tribunal.
And when he is declared foreigner, he has to be arrested. He was arrested. While arresting, he's saying that I'm not the person. I'm the brother of this proceeding. How can the tribunal?
Where is your brother?
Lordship.
Where is your brother?
He is outside this.
Outside. You bring him.
That's why the police.
Exchange. Let there be an exchange program. Exchange program will allow your petition.
All along
He was in interim Lordship. From 2020, he got interim protection, Lordship.
in another case, he has been declared foreigner.
Oh.
He has been declared foreigner. That's why he's taking the
My
risk,
brother
my
is declared foreigner, Lordship, actually.
Hmm?
My brother is declared foreigner. Subsequently, he was 2020. He was
You are in interim protection.
Interim
So why? What is the urgency?
No, Lordship, but he is behind the bar. After, in spite of interim order in 2020, after appearing on younger brother's case, he was behind the bar.
He has put his leg on the shoes, man.
So what is the interim order?
This is interim order, Lordship.
Interim order was, my lord, there was a, my lord, opinion against this, according to him, is the person where there was a declaration against that he appeared, approached with this honorable court granted him bail. Now in the next case, he appeared again,
Oh.
knowing that I'm this person. He continued for 2 years. Then
You will
while
be given
declaring, he
interim,
said,
your
"No, no, no, I'm
interim,
not
your
this
interim will be extended in your case, not in this case.
person." That's why, my lord.
You get your brother. You get your brother.
In fact, he played with the tribunal also, my lord. This is extremely, my lord, wrong.
Will not be
Yes.
showing any favors to you.
Yes.
A person
He
who
put the
who
tribunal.
approaches the court or the tribunal with malafide intention, we are not
Yes,
with you.
whole malafide intention, he appeared, he continued while arresting, my lord, only.
We can dismiss the case. Let us dismiss the case. Item number 46. Yes, what is it? Please argue your case.
In this case, Lordship, 7/3/2019, Lordship, he was declared foreigner
Just
by
a minute,
tribunal.
please. Just a minute. Yes.
7/3/2019.
What is the date of the opinion?
7/3/2019. 7/3/2019.
7/3/2019.
After it was preferred And on 17/3/2022, Lord, he was granted interim protection.
He was?
17/3/22, he was granted interim protection by this honorable court.
Interim granted in this case?
Okay, Lordship, in this case.
Opinion is by which tribunal?
Lordship, Foreigners Tribunal 9, Nagaon, Assam. Page 10, Lordship.
What is your case?
Lordship, thereafter I contested the case by filing a written statement. Written statement is at page 16, Lordship.
What is the name of the petitioner? Muhammad Abdul Hussain.
Abdul Hussain, Lordship.
What is the interim order you have given here? 17?
Interim order, Lordship,
17-3.
17/3/22, Lord. This is the interim order, Lordship. May I submit, Lordship?
We have got it. Okay. What are your documents?
Ground birth certificate, Lordship, at page 25.
25.
25.
What's the relevant petition, huh? Other matters may not be possible. My brother has a single bench. So this will take some time. We'll complete with this matter.
Then let it come on Monday, Lordship.
No, we are completing this matter.
Completed.
Not for your matter. For your matter, we'll sit up till 4:30. No problem. Item number, page number?
Page 26, Lord.
26.
Page 25, it is ground birth certificate. Page 25.
25 is Gauhati certificate.
Lordship.
25 is NRC.
NRC in my petition, Lordship, NRC is 26 and Annexure 5.
Gauhati certificate is page 23. Sarkari Gauhati.
Sarkari Gauhati.
Pramanpatra.
Lordship.
Date?
Dated, Lordship, 29/6/26. 25.
Not 25, 26.
26, Lordship.
29/6, 2016.
2016, Lordship.
16. Gauhati certificate.
Then, Lordship, NRC details.
First, let us see this. What is this? Amir Hussain. You are Abdul Hussain.
I mean, Abdul Hussain. My father's name is Amir Hussain.
What is this Gauhati certificate?
My father's name, Lordship.
Huh?
My father's name is Amir Hussain, Lordship.
Now, what is the certificate? Please read.
May I read, Lordship?
Please read, yes.
Here,
Dara Praman Patra hoise.
Dia hoise Mrito Amir Hussain, son of Mrito Abdul Hussain Namghar, Kothiatuli, Kampur, permit number so and so, Jila Nagaon, Assam. For Ullekh Srimati, Miss Mrito Mr. Amir Hussain, moi, I know him very well. He
knows whom?
He knows his father, Lordship.
No,
Amir Hussain is father, Lordship, the petitioner's father. The government certificate has been given.
Gauhati certificate says that he knew your father.
Yes.
Your father's name is Amir Hussain.
Amir Hussain. He is a permanent resident of that locality, Lordship.
Respect of a dead person.
Lordship.
Amir Hussain is the father of the petitioner.
Lordship, father of the petitioner.
Okay.
Then Lordship, NRC, in NRC, also Lordship, his father's name is reflected. I will see the NRC details at page 26.
NRC. Amir Hussain.
Amir Hussain. Then I have a next one, Lordship, page 28. There is a Khotian of riot, where my father's name is there, Lordship. Yes, my father's name is there, Lordship. Amir Hussain.
Amir Hussain.
Amir Hussain. Then kindly, Lordship, kindly say, peruse page 31, Lordship. There's Jama Mandi, Lordship, where my name is reflected, Lordship. Serial number 8, Amir Abdul Hussain.
Jamamandi.
Jamamandi, Lordship.
Page?
Page 31. And the last column, Lordship, last paragraph, Lordship. May I read, Lordship? In compliance with the order dated 3599 passed by the circle officer in Sitha mutation in respect of land measuring 4 katha 3.5 lasas, land measuring 2 biga 2 katha 17.5 lasa, covered by Dag number 28, land measuring 1 biga 16 lasa, covered by Dag number so and so, is allowed in favor of Abdul Hussain, son of late Amir Hussain. It is the
But this is not by inheritance, this is by purchase.
Purchase.
How do you to connect your petition Abdul Hussain with this Amir Hussain?
Actually,
this is in respect of some other land. It is not inherited land. It is purchased by you in your individual capacity. And the father of the Vendi is also Amir Hussain. Now this Amir Hussain, first you have to establish that Amir Hussain, this whose documents you are using or you are projecting is that of your father first. And secondly, more importantly, these documents are post 1971. Gauhati is 29.
69, Lord.
16.
68, 69. Jamamandi. Certificate copy Jamamandi for the year 1960.
Jamamandi?
Jamamandi, Lord.
Jamamandi is of which year?
68, 69. Lord.
When did your name enter? It is not because of Amir Hussain. Your name has entered because of your purchase.
Purchase, Lord.
That Ram Prasad in presence of in the name in the against the name of Ram Prasad Bordoloi, your name has come.
Lordship.
Nothing to get being inherited from your father. And this is a recent order. Order is of 5/3/5/1999. Right there is all. Right there.
3599. Order is of 3599.
Yes.
3599.
So how do you make a link?
That's it. And I have at page 35, Lordship. There's a voter list, Lordship.
Let us see.
35, Annex 9. A serial number 807, Lordship. Hussain Banu is my mother, Lordship.
Age?
Page 35, Annex 9.
Certified copy.
Certified copy.
Next, see the, please read the vernacular. 2018.
2018.
18, how is it relevant? 2018 voter list. What is there? Whose names are there?
My mother's name is there, Lordship. And
What's
my
your
name is
mother's
also
name?
Hussain Banu, Lordship. Hussain Banu.
Hussain Banu.
Hussain Banu. And my father.
Not Hussain Banu, Hassan Banu.
Hassan
Banu.
And my name is also there, Lordship. Serial number 808. That is Abdul Hussain. Abdul Hussain and my father's name, Amir Hussain. That two names are, Lordship, reflected.
Abdul Hussain.
Hussein.
Hussain. Petitioner. 52. Who are this Palani Khatun?
And I'm not aware, Lordship, who are they?
Huh?
I'm not aware of other two, Lordship. Only I'm
No, Falani Khatun, Abdul
Falani
Rahim.
Khatun, Abdul Rahim.
Not aware.
At least, Lordship, Lordship.
Your wife and your
Wife,
children.
wife and
You do
children.
not know
Wife and children.
who is your wife, is your
Wife
children.
and children. Children. And another, Lordship, at page 38, their 2019 voter list, Lordship.
Two 2019. These are not relevant,
Clearly.
Mr. Sharma.
Mm.
Hassan. Abdul Hussain.
Lordship, kindly turn to page 11, Lordship. That's a judgment. Last para, Lordship. Last para of the judgment, Lordship.
Judgment is at page?
Start from, Lordship, page 10, kindly see page 11, Lordship, last para. It is in the evidence of OP1, Muhammad Abdul Hussain, that his father's name is Amir Hussain, mother's name is Hassan Banu, and his grandfather's name is Abdul. His father had exercised.
Just a minute. Last page, internal page 5.
Page 11.
Internal page?
11. Page 11.
No, internal page. Okay, internal page 2.
Annexer. May I read, Lordship?
Please.
It is the evidence of OP1, Abdul Hussain, Muhammad Abdul Hussain, that his father's name is Amir.
How many witnesses are there?
5 witnesses are there, Lordship.
5 witnesses.
5 witnesses are there.
Yes.
It is in the evidence of OP1, Muhammad Abdul Hussain, that his father's name is Amir Hussain, mother's name is Hassan Banu, and his grandfather's name is Abdul. His father had
Mr.
exercised.
Sharma, what is your date of birth or year of birth? What is your age?
Lordship, 1/1/2/1964, Lordship. My date of birth is 1964.
Where is your voters list?
Voter list, Lordship.
Your first voter list is when you attain the age of 52. Prior to that?
That's lordship. So I could not collect lordship, the voter list from the client lordship.
What about the voter list of your father? From where you, if you are born in 1964, you have a very good case to project. Show the voters list.
Absolutely. I'll seek instruction. From I'll seek instruction from my
Instruction,
client.
that stage is already over. 20 matter we are declaring for final hearing. So what are the 5 witnesses? Who are the 5 witnesses? Petitioner and who else?
Brother of the petitioner, then Gauhati.
Petitioner, then brother. Name of the brother?
Abdul Hassan.
Abul.
Abdul Hassan.
Abdul is you.
I'm Abdul Hussain.
Oh.
He's Abdul Hassan.
Abdul Hassan. And Gaungura. And 2 more?
Then lordship, 2 Gaungura have been examined. Then lordship, Seku Sheikh, an independent witness, he has been examined.
Name?
It is Seku Sheikh. CHECHU CHECHU. Then SEIKH.
Sechu.
Seku.
Sechu. Sheikh.
Sheikh. SEIKH.
And number 5?
Number 5 is Seku Sheikh.
No. Seku is the petitioner. His brother Abdul Hassan.
Hassan.
Gaungura.
Then OP3 is Srimati Bendre Rangfarani, government Gaungura.
No, Gaungura.
Then another.
4 is Seku Sheikh.
Seku Sheikh is one of the independent witnesses.
Then thereafter you said 5 witnesses.
5 witnesses. Then lordship Abdul Jalil, another Gaungura of Kobai Kata and Samskara Kisam. 5 witnesses.
Before going to these aspects, madam, I have seen the records, madam. There is no records of pre-71 of the petitions, but that is the only. Now, his date of birth is something 1964, but for these petitioners. And father's document is not there. Parents' document prior to 71 is not there. No, to establish link, my lord, there must be some document of prior pre-71. That is not there.
That's the main document.
Main document, main track. Only one document was there. Yes, that is my lord, the NRC, one NRC document given by my lord SP Border, some SP Border Police of 1951, and that is this is in the name of Amir Hussain. He only relied this to Exhibit 8. No? Exhibit 8. This is the
What is Exhibit 8?
This is an NRC, my lord, NRC of 1951, and this document is issued by some Deputy Superintendent of DSP B. Nagaon, Assam.
Page number?
Page number it is.
Are you at page
I'm
25?
to record.
Page 26.
25.
Next up.
It is in the record. That must one. And this is certain position of law, my lord. This document cannot be used as a piece of evidence because numbers of cases we have reported, my lord. Tribunal case, one case identical, my lord. This is in WPC 2019. 2019, 2 GLT, please 45. 2019, 2 GLT, please 45. WPC number 6090-2016. Decided on 15/3/2018.
Name, please.
Yes. Party, sir, Abdul Majid. Para 11 of that judgment, my lord.
How do you spell Majid? M-A?
Majid, M-U.
No, no,
Abdul Majid, M-A-J-I-D.
Z.
J-I-D.
This is WPC 609015.
Yes, 609016 man.
16.
16.
Para?
Para 11. Exhibit 1 is stated to be the true copy of National NRC 1951 issued by the Deputy Superintendent of Police Dhuburi. Same things here, same things here, madam. Dhuburi on 17/10/1985 containing the name of so and Hanif Singh, NRC 1950. Hanif Singh. The NRC 1951 is prepared on the basis of Census Act 1948. As per section 15 of the Act, Census Act 1948 record of census are not open to inspection and thus not admissible in evidence. Therefore, in Hanbes Sheikh, Hana versus Sheikh versus Union of India in 1970, Assam LR 206, a single bench of this honorable court categorically held that NRC extract produced to prove domicile in India is not admissible in evidence for any purpose. We are in complete agreement with the views expressed by the learned single just in Vanavasa 6. Therefore, Exhibit 1 is no evidence in the eye of it. This is same thing, but the same document. So this is related to numbers of judgments, madam. And this, in fact, the Deputy Superintendent of Police has no authority to issue the NRC, that document. If that is not there, not a single document of prior to 1971 is there. Now, even though we see the evidences, a lot of the numbers of witnesses, but what you will establish, madam? First of all, there must be, he has to establish that his parents were citizens and his parents were there in prior to 71. Then he has to link himself to some document. Now, to link something, to link himself to someone else, the no basis is not there. Basis itself is not there. That is the only case here. And there have been some documents of prior to 71, then this examination of these documents were relevant. Otherwise, it is irrelevant, man. First of all, he has to establish his father's citizenship. Then only he can link to himself.
The Lordship may remand back this case to that. Tribunal.
Remand for what? You
For-
make out a case for remand, will remand.
To pass a reason order by the Tribunal, Lordship.
What more reasoned order is required? You show us one document by which a link establishes, or it can be stated that you are in India prior to this specified date.
And I'll file affidavit, Lordship, additional affidavit
For
annexing such documents.
you, how
If
can
Lordship
you?
give some time.
In a writ jurisdiction, certiorari proceeding, this is not an appellate forum that you invoke 4127.
So, or
It's not
Lordship may
appellate
give
forum
some time, I will
that you take
produce,
leave to
if such documents
introduce
are
new
there, Lordship.
documents.
Lordship may if give some time, I'll produce some documents, if there is, if any,
Mr. Sharma, this matter was not, would
2020.
not have reached.
20.
You'd have gone time, but you made a mention in the morning that there is urgency. So you've given time to a matter. We have heard this matter.
Lordship.
Now we'll fix for judgment. Heard Sri A. Sharma. Then on this side also, huh? Fines and N. Kalita, ECI, and RB Bora State Council and B. Sharma. Where is Madam B. Sharma? TGC. Judgment is, hearing is concluded, judgment is reserved. The rest, courtmaster will give date. Any matter where interim order is still today?
Lordship, item 27, Lordship, interim order to be extended, Lordship.
27. Paucity of time will not permit this matter to be taken up today. On request, list on this tarikh, 20 May 2020. 6, para interim order passed earlier to continue till the next day of listing. Other matters, courtmaster will give dates. 25. Item number 27.
Seven.
Oh.
Much obliged.